I'd like to call the Committee of Commerce and Labor to order. Clerk, if you would call the roll.
You have a quorum, Mr. Chair.
Thank you. Okay, the first order of business is judicial interviews for the State Corporation Commission judge. Judge Dimitri has retired early, opening up a 2-year term for the remaining 2 years of Judge Dimitri's term. We're going to interview 3 candidates today. I'm going to ask, is Meade here? We'll take them in alphabetical order. Meade, Browder. Okay, Meade, there you are. I'm sorry. Are the other 2 candidates in the room? There's Maureen and, all right. If I'm going to ask you two to leave the room, please, while we interview, so we're not doing those. And Frank, if you would pass out the forms on Meade, Browder, and the candidates. Meade, please come on up. For those that are getting these forms, I'll ask that you look at them and leave them at your desk. There's a lot of confidential information on this and not open for circulation, but your view. Meade, please tell us a little bit about yourself, why you want to be judge.
Thank you, Mr. Chairman, members of the committee. Good afternoon. I'm Meade Browder. I recognize that and understand that there are many considerations that will go into the legislature's selection of a judge to serve on the State Corporation Commission. I've got 3 points I'd like to make in support of my candidacy, and I'll try to be very brief in making them. First, I have deep experience as a regulatory attorney in utilities and insurance matters before the SEC. I've been in the trenches for more than 20 years in all sorts of cases at the Commission, so I know the work. But I do appreciate that my extensive experience with the many technical and legal issues that come before the SEC does not alone check all the boxes for this job. So the second point I want to make is that I understand the role of a commissioner. Since 2002, I've been a section chief in the Attorney General's office, where my job has been to represent the interests of the people of Virginia's consumers. This is a statutory duty of the office. But this new job that I'm now seeking is to be a judge, not an advocate, and I know the difference between the two. The third point is that I believe that I have the broad perspective and the personal attributes that are necessary to be an effective commissioner. I've served under Attorneys General Kilgore, McDonnell, Cuccinelli, and now Herring. I believe the fact that I have had the trust and confidence of this diverse group of AGs while serving one of the more public and politically sensitive areas of the office speaks to my capacity for sound judgment and professionalism. I know that you don't want, and you should not want, a commissioner with a myopic view of issues who fails to see the big picture. I believe that my reputation, at least among those who know my work, is that in dealing with the regulated community, the environmental community, and all others, that I've always been someone that they could work with, and that I've never pushed for an outcome that would fail to strike a reasonable balance, considering the facts, the law, and the overall circumstances in each situation. And despite the fact that I have been a government lawyer, I do have an appreciation for the goals and objectives and the challenges of the business community. Before going to law school, I worked in the private sector in the highly regulated insurance and financial services industries. As a licensed insurance agent and investment sales representative, I was personally subject to regulatory oversight by the SEC. I would also note that my spouse has for many years been with one of the largest private employers in the Richmond area, and their family has benefited from that company's success. So the final thing that I want you to know is that I have no agenda. My desire to be on the commission is simply a natural and logical extension of my career path in public service. It's been an honor and a privilege for me to serve the Commonwealth over the past 2 decades as a practitioner before the commission, and it would be the highest honor and greatest privilege for me to be able to continue this service as a member of the State Corporation Commission. So
Thank you.
thank you for having me appear today. I'm happy to answer any questions that
Thank you, Meade. Are there questions for Mr. Browder from the committee? I just have one, Meade, and I'll put it on you. It's been my experience with the SEC over the last however many years I've been up here, a couple of decades anyway, that while they do a good job at trying to do all they can to bring in electric rates as low as possible, that they lose sometimes the big picture of ultimately what's going to bring down electric rates in the long term. And by that, let me try to rephrase the question or rephrase the statement a little bit. If I have a company, I can make a whole lot of money 1 year by not investing a single nickel back into my company. And while that 1 year, maybe the year and the year after, I might actually realize making a little bit more money, what I've done by failing to invest in my company is I haven't prepared this company for the next 4 years, and I'll end up going out of business from failure to keep up and do that. One of the problems that I have seeing from a perspective of the State Corporation Commission is they take that myopic approach, despite many statements getting more and more bold from the General Assembly as to what the policy is for the future of Virginia and ensuring that those investor-owned utilities make the necessary investments for the long-term good of all Virginians, and that myopic approach. What's your view on that, as opposed to when you read something that comes from new legislation out of the General Assembly? What would be your position as a judge in terms of executing the policy that you read in the General Assembly?
Right. Chairman Wagner, I certainly understand your question to be in the context of electric utility regulation. Certainly, I think any candidate will tell you that they're planning to follow the law. I'm aware of your particular interest in that area. That's why actually in my prepared remarks I referenced the need to not be myopic and to have a broad perspective. I think that that any commissioners would work within the regulatory framework that you all have laid out. So if it's in a biennial review proceeding or a triennial review proceeding, you look at the costs, look at the revenues, and make the judgments that need to be made. I agree with you that having you can have too much of a myopic or narrow focus. I think that my background in the AG's office, have been plenty of instances where we have not always taken the short-term view. One example would be, I know that this is a natural gas case, but there was a case where a company was brought before the commission for their alleged over-earnings, and the evidence showed that indeed the rates could be reduced. But rather than jumping on to that issue and arguing for a rate reduction, we supported a major infrastructure project for a major pipeline project under the Elizabeth River. So I think that's one example of where I have taken the broad perspective, and I would continue to do that on the commission.
Thank you. Okay, any other questions? Thank you. Yeah. Oh,
Mr. Chairman,
Senator
I
McDougall.
did have one. In your role as advocate for consumers, do you feel that it is always your requirement to advocate for the lowest cost electricity for those consumers, regardless of the form that comes in?
Yes, Mr. Chairman. Senator McDougall, the short answer to that is no. I would say the lowest reasonable cost, with the emphasis on reasonable. I think that, again, I think my reputation for those who know my work, certainly I have an advocacy responsibility like any attorney does, have a client interest to represent. But I have never taken the view, and I don't think the office has taken the view, that it's always the absolute lowest rate, no matter what. That really, I mean, it dovetails with Chairman Wagner's question, and I don't believe that my background, my record would prove that I have always been just locked in on the absolute lowest rate.
Mr. Chairman,
Yeah,
follow-up
Senator
question.
McDougall.
So would you think that net metering, where a rate paid above wholesale rate, is in the best interest of consumers and maintaining lower cost electricity for them?
Right. So you're asking specifically about net metering issues. I know there's a whole host of issues there and special interests that are seeking certain outcomes there. I don't believe I've taken a position in the past specifically on behalf of the office, specifically on net metering rates or.
Mr. Chairman,
Senator McDougall.
I guess I'm asking specifically, do you think net metering rates, if you're required to pay, if the utility that's regulated is required to pay more than the wholesale rate where they could buy that electricity on the market, is that in the best interest of consumers?
Under the way you've laid it out, I would think probably not. I would assume the analysis would have to look into overall benefits to the system and all of that. But I understand your question. I would think that would be more than likely not the case, again, unless there was other evidence that showed there was some kind of broad-based benefits to the system as a large.
Thank you.
Any other questions? Thank you, Mr. Browder. I appreciate it.
Thank you, Chairman.
Okay. Richard, I need a motion to find and qualify.
Mr. Chairman,
Yes.
I would move that we find Mr. Browder qualified.
Okay, is there a second? Okay, it's been moved and seconded. We find Mr. Browder qualified. Clerk, open the rolls. There's the answer. Thank you.
11 ayes, 0 nays.
Okay. All right, next is David Clark. Somebody round him up for me. There he is. David, why don't you take us a minute and tell us why you'd like to be an SCC judge?
Yes, Mr. Chairman, members of the committee, David Clark. Interested in this position for a number of reasons. I'll give you a little background on myself, if I might. I am a proud native Virginian, product of great public schools in Chesterfield County and of the University of Virginia and of the law school at the University of Richmond. My interest in the position of Commissioner of the SCC is longstanding. In fact, my parents were introduced to one another by now retired Judge Preston Shannon and his wife Ann. So I guess you could say that my interest comes, in a sense, naturally. Prior to law school, I worked for 3 years in banking for a state chartered savings and loan. And for the past almost 35 years, I've worked with 3 outstanding law firms where I've previously served as managing partner and currently serve as member in charge of the Richmond office of Eckert Siemens, Charon, and Malott. I've been fortunate to have many wonderful personal and professional mentors and role models, and to them I owe a great debt of gratitude. Many of those role models, including a number in this body, have provided an inspiring example of public service. I see the position of Commissioner of the SEC as not only an honor, but an opportunity to give back, to serve. I believe most of you are somewhat familiar with the advocacy work I do on behalf of clients as a lobbyist, and you may know that in addition to my work here at the General Assembly, I've worked for many of those same clients before the state agencies and bodies which regulate those interests, including the State Corporation Commission. My legal work also includes a significant corporate and transactional practice representing a wide range of businesses and individual clients. My work in matters regulated by the SEC have also covered a wide range of subjects. I've assisted insurance agents, agencies, and underwriters on a variety of regulatory and licensure issues. I've represented a coalition of businesses and individuals before the Commission in the development and enforcement of regulations regarding portions of the lending industry. In the area of telecommunications, I've represented both incumbent and competitive providers of both landline and wireless service. And in the area of energy, I've worked for both incumbent natural gas utilities and competitive suppliers of energy, including marketers of green energy. Outside of my professional life, I have been blessed with a loving family, including a wife of 30 years and our 2 adult children. I've been privileged to serve my community on the boards of a civic association, an independent school, a leadership training program, and in the leadership of our church. In the area of personal interest and advocacy, I helped start and lead an organization for the purpose of preserving as public open space a small but important tract of land in Richmond's West End. I believe we were the first to establish that a locality in Virginia can place a conservation easement on its own property to ensure its conservation for generations ahead. We weren't the first in Virginia to obtain a conservation easement, but we were ultimately successful, and we established the precedent for the city of Richmond that led to the placement of a conservation easement on other important public space in the city, including portions of the James River Park system. So you might ask, why me and why now? I would bring to this position an appropriate demeanor and a respect for the role of the Commission as the agency that implements legislative policy and a recognition of the need to listen to all voices. Moreover, I would bring to this work an intellectual curiosity and a breadth of experience and expertise that are well suited for the extensive regulatory reach of the Commission. I cannot imagine a more interesting and challenging time to serve as Commissioner. So much is changing and so rapidly. I fully understand the charge to the judges of the Commission is to apply the provisions of the Constitutions of Virginia and of the United States and the laws enacted by the General Assembly to the facts presented in each case. I also appreciate that it's important that we have commissioners who recognize the nuances of the modern regulatory arena that are articulated in the legislation enacted by this body. I'm humbled by the prospect of serving alongside our current commissioners and following in the footsteps of the women and men of highest integrity who have served previously in this role. I respectfully request that you certify me as qualified to so serve.
Okay.
Thank you.
Are there questions for Mr. Clark? David, I have one if I could, and I'll try to better articulate. It's the same question I asked the previous interview. I'm familiar. Let me give you something I'm very familiar with. There's the previous owner of a shipyard that I own. He took a leap of faith. He had a marine railway, and he pulled boats up there and repair the boats and put them back in the water. And he went ahead and signed a lease with the city of Newport News so they could put a big travel lift basin in. He went out and borrowed $2 million to buy a new travel lift on a company that perhaps didn't do $2 million with the revenue in a year. He went out on a limb and made that investment. And the returns on that investment, I was able to, when I purchased the company from him, take advantage of him because he had the foresight and the look-see to be able to go in and say, I got to prepare for the future. I need to make these changes if I'm going to be competitive and keep my business open. I suspect if he hadn't have done that, his business would be out of business, and I would have never had the opportunity to buy it and take it to the next level. It's been an issue with me and the State Corporation Commission that they have been reluctant to make those type of investments that I think will propel Virginia into the future. And it becomes an increasing level of concern that the commissioners come up here, and particularly Senator Sasslaw has been on them, as well as Senator Norman has been my witness over the years, saying, you would follow what the General Assembly says, and then we come back a couple of years later and have the same issues and the same series of questions over and over again. This year, you're getting pretty clear instructions. They're going to be sent to you because we're very concerned here that the State Corporation Commission has become very myopic on let's deliver the lowest possible rates we possibly can for a consumer and fail to make the necessary investments to do that. And we're talking pennies on an electric bill, but we're talking about a future generation that I'm very excited about with the investments made in that. Talk to me about what your feelings are on those particular issues.
Mr. Chairman, I understand the issues that you're raising. Certainly, I think the Commission has had as its charge the protection of ratepayers, appropriately so. I do think that as I listened to the debate this year and in recent years in this body, it's clear to me that the sense of the General Assembly is that we need to have more investment. We need to look at renewables. We need to look at energy efficiency programs. And those things don't come without a price tag on them, no question. So what my sense is that the nuances that I hear from this body are that we need to have a fresh perspective. We need to look at the operations of our utilities as the businesses that they are, recognize that they need to make tough decisions each day on where they're going to invest their capital. So I fully support the interest in investing for the longer term and not just for the short term. What is necessarily the lowest rate on any given day?
Okay. Are there any other questions? Senator Stewart.
Thanks, Mr. Chairman. David, I'm not as familiar with the SCC as perhaps I should be because I just practice in regular old courts. But I know that you have a substantial practice of representing folks that are regulated by the SCC. You've done work before them, work here on behalf of all those clients. How does that affect you if you were to sit on the SCC in terms of now dealing with issues of those same clients? Does that present a conflict of interest that you have to recuse yourself on and we have to find a replacement? Just walk me through how that would work, please.
Mr. Chairman, Senator Stewart, I certainly wouldn't be the first person to go on the commission who has been in a private practice. I believe that in dealing with conflicts of interest, they would be handled with consulting the commission staff. And I'm sure that for a period of time, I would have to not participate in cases involving clients that I have represented. As far as my personal interest in clients, I think we all who are lawyers know that we're charged with zealously representing our clients' best interests. And they sometimes are in line with our own personal interests, but not always are they in line with our personal interests.
Okay. Are there any other questions? The chair will entertain a motion. Senator?
Maybe be found qualified.
Been moved and seconded that Mr. Clark be found qualified. Clerk, open the rolls. Okay, thank you,
very
David. I
much.
appreciate it.
14 ayes, 0 nays.
Thank you. Okay. If we could get Ms. Mattson in here. Morning, Maureen.
Good morning.
Afternoon.
Afternoon, I think it's
Afternoon. Why don't you tell us why you want to be State Corporation Commission Judge?
Oh, goodness. Several reasons. First and foremost, because I think I am the perfect combination of experience and skill to do the job well. And I have a high regard for the commission. I understand how critically important its work is to all Virginians. Citizens, individual citizens, businesses, industries, everyone is impacted by the work of the commission. It's a critically important body that many folks don't even know exists or what it does. But I am certainly very familiar with that and would like to be a part of the work that it does. Also because it's a tremendously exciting and dynamic practice at this point in time where I think the regulation of electricity was once perhaps thought of as mundane and sort of the same day in and day out. I think today with new technologies and new energy markets and all sorts of things moving around the world with regard to regulated utilities or unregulated utilities, it's just exciting work and I'd love to do it. And I think I have the skills and the experience to be an effective servant at the commission.
I'm sorry. Okay, I've asked the same question. I'm going to ask you one more the same time. Unfortunately, the audience gets to hear it for the third time. But let me just say this, that companies that fail to make investments in the future fail. They might realize more profit in the short term by not making those investments and not having a negative cash flow of those investments. But in the end, because they didn't make those investments and keep up, they ultimately end up with a more expensive product and ultimately fail. I feel and I sense the same things going on with the power grid. I think those states that make those investments will ultimately offer their consumers lower cost electricity. More fuel you take out of the equation, the cheaper your electricity is going to be in the long term. That would be renewables. The more ability you have to store excess electricity as opposed to letting it go to ground and be wasted, you're going to realize those investments, and those investments take capital. The bill that we're working on during this session does a lot of those things. It also lowers rates. Tell me, and it's been my experience that the State Corporation Commission has been loath to make those type of investments in the future, despite what I thought was pretty clear direction from the General Assembly over the past 20-some years I've been on here. Tell me what your feelings are in terms of the legislation that you get, your approach to it as judge.
Well, first of all, my career as a lawyer is grounded in trial and appellate work. What that means is that at the heart of what I do, what I know how to do best, what I'm trained in, is applying the law to the facts. So the law, as adopted by this body, and the policies inherent in that law are what has to be applied to the facts that are before the commission. So to the extent that this body is incorporating all of those issues that you've just identified, and you've certainly identified a dozen that I think make the work fascinating and exciting, and time for some change in perspective. I think there needs to be a broader, wider vision of all of those things that you were discussing. So first of all, a commissioner needs to apply the law and look to the law and the direction of the General Assembly with regard to how it handles the cases before them. But certainly the other piece of that is balance. And I would argue that I have been on both sides. I have represented consumers and worked hard to keep rates low. That was my job in the Attorney General's office, leading the Division of Civil Litigation. But then I've also worked for a governor who was all about expanding the energy industry in Virginia. And I've gotten to work with our utilities and our energy companies and all of the businesses that rely on them, which is just about all of them. And I've learned about the complexities that they deal with, the environment they work in, and all the exciting things that are possible. So I would bring to the job a very broad vision of all of that and a very balanced perspective, and listen carefully for all of those issues, and of course apply the law as adopted by this body.
Any other questions? Chair would entertain a motion. It's been moved and seconded that Ms. Mattson be deemed qualified. Clerk, open the rolls.
14 ayes, 0 nays.
Thank you. Maureen, congratulations. Thank you. Okay, we're on to the docket, and take them in order. Delegate Byron. What do you have for us today?
I have House Bill, put my glasses on, House Bill 1583.
House Bill 1583. Committee, pay attention.
Thank you, Mr. Chairman, members of the committee. As a long-term member of the Broadband Advisory Council, I know how essential it is to have broadband in every region in Virginia, and I'm sure there isn't anybody sitting up there that hasn't heard that recently. Today, a region without broadband is a region with an economy that can't grow, can't create jobs, and cannot provide a world-class education to its children. And I would say to you, the last couple of years, we've discovered the internet highway is almost as critical as the road highways that we all travel on. Go Virginia, recently we had a meeting with the Broadband Advisory Council, and they identified that some of the top priorities of the Go Virginia regions are broadband and access to broadband. And the one thing that that I felt was really lacking that we need to make sure that we have in place is a similar model that we did with workforce when it became so critical to the Commonwealth that we had to actually challenge and go out and do something. And that was to make sure that we had someone that was the go-to person, someone in the executive branch that would be able to be accountable for progress, be able to devote 24/7 to making sure that the Virginia is represented in so many different areas. We have, as you well know from your area of the state, Senator Wagner, we have the transoceanic cable lines, and then we have areas of rural Virginia that don't even have last mile. So you have two different aspects of broadband. It's no longer just a matter of those that are not connected. But the question is making sure that those larger areas of economic opportunities, that we have someone that's in Washington that is there to make sure we get research and grant funding available to us. We no longer have a Secretary of Technology. This would create a chief advisor in the Secretary of Commerce and Trade's office that would be responsible for coordinating and it be a central depository. Right now, there's not even a central depository. Department of Housing and Community Development handles grants. We have grants now from Go Virginia. We have grants from the Tobacco Commission. There's the federal funding that's coming down. There's broadband deployment going on all throughout our state, yet there's not one central area that anyone knows what's really, truly going on. So this maps out the responsibilities and duties of a chief advisor. It's envisioned as someone that isn't just a political appointment, but someone that has the expertise and ability to handle the position and understand what that position entails, to also have metrics and things in place so that they come back and not just report, but actually report to us what progress is being made in the Commonwealth. And that's pretty much what the bill does. And I hope it'd be a pleasure of the committee to support this, and I am also willing to answer any questions you might have.
Are there questions for the patron? Senator Norman. I think the proper motion, Senator Norman, would be report and re-refer to finance.
Well, that's a good place to.
Okay. Okay, it's been moved and seconded that the bill be reported and re-referred to Committee on Finance. Is there anyone opposed to the bill? Seeing none, clerk, open the rolls.
Thirteen ayes, 0 nays.
Thank you, Delegate Byron. You got anything else?
Thank you very
today?
much. No, I have a few in finance, though.
Okay,
Thank you.
all right. Delegate James.
Good afternoon,
Chafee.
Mr. Chairman.
Yes.
It's my pleasure to present to you and the committee bill very, very similar to, in terms of purpose, on a smaller scale. House Bill 1552 primarily directs the Virginia Board of Workforce Development to recommend strategies to identify and encourage discouraged workers, unemployed individuals not currently served by the workforce system, and measurably improve the performance of the Federal Workforce Investment and Opportunities Act of 2014 Title I youth programs, so they can lead to employability and development of skills to enter the workforce in high demand fields. And the board would present their recommended strategies by October 1, 2019. This is an idea that was worked with the administration as well as certain workforce boards. And we think it addressed some of the pipeline that came out of a meeting that we had of employers, and we had a meeting with the workforce. And if you look at things like the labor market participation rate, you can see that about 40% of people in this category, once you strip out the military and prisons, they're not working and they're not coming to our one-stop. So this is a strong step forward to have a plan, and it dovetails with the requirements that we have to hire more people who have high skills.
Thank you. Are there questions for Delegate James? Is there anyone opposed to this legislation? It's been moved and seconded that House Bill 1552 be reported. Clerk, open the rolls.
Fourteen ayes, 0 nays.
I
Bill
thank the
supported.
committee.
Thank you, Delegate James.
Thank you.
Appreciate it. Delegate Ransom.
Mr. Chairman, members of the committee, I have House Bill 686 and I have a substitute.
Okay. Been moved and seconded that substitute to House Bill 686 be adopted. All those in favor say aye. Any opposed? Okay, the substitute's for just Delegate Ransom.
Mr. Chairman, this is a banking bill that will refund, banks can refund their customers dormant fees. It's very similar to Senate Bill 253 that passed the Senate. And what it will do is conform my House bill to Senator Dance's Senate bill. And the substitute today preserves the intent of the original bill. It just has clarifying language that Mr. Munyon put forward to us so that This version will attempt to further clean up the language just to make it clearer in the code, and I'd like to thank him for that. The substitute provides necessary clarity to banks on their options when they refund the dormant fees.
Okay. Are there questions for the patron? Senator Dance? Okay. It's been moved to section substitute to Senate House Bill 686 be reported. Clerk, open the rolls.
Fourteen ayes, 0 nays.
That bill's reported. Thanks,
Thanks.
Delegate Ranson. Delegate Head.
Thank you, Mr. Chairman. We have again House Bill 139, and after having worked with stakeholders, I think we've got a substitute
Okay.
for Mr. Bunyan.
Senator Norman motions and Senator Obenshain seconds that substitute be adopted. All those in favor say aye. Aye. Any opposed? Okay, the substitute's before us. House Bill 139.
And thank you, Mr. Chairman and members of the committee. Just to touch base again, I'm going to turn it over to Mr. Jamerson, if that'll be okay, to sort of walk you through some of the changes. But the folks have done a great job of, I think, addressing some of the issues that were raised. And I'll just, rather than belabor the point, turn it over to them and let them walk you through it, if that'll be all right with you.
Mr. Chairman, good afternoon. Hunter Jamerson, General Counsel of Virginia Academy of Family Physicians. I know my medical society colleagues will follow me as this bill does affect all providers, not just family physicians. But the substitute in front of you is a result of the week's worth of discussions between our physician organizations, the Virginia Association of Health Plans, its member health plans, taking contributions as well from Mr. Chairman, members of your committee. We think it's a much improved bill that addresses the concerns raised to you last week. Understandably, there are still philosophical differences of approach here between physicians and health plans, and you'll hear those borne out today. But I want to note the 6 things that have changed in the bill since it was last before you. First, most significantly, beginning on line 66 of the substitute, Mr. Chairman, the substitute contemplates a patient disclosure now provided by the physician to the patient, identifying to the patient the steps that have not yet been taken by the carrier to credential the physician that the patient may be seeing that day. It's important to know, Mr. Chairman, many of these things have also been, these traps have been run by the physician's employer. Some of these traps have been run by the Virginia Board of Medicine in the licensing process. But recognizing a concern of the health plans was that patients may assume that certain steps have been taken that have not yet been taken. This disclosure addresses that. Mr. Chairman, additionally, in the substitute, we have clarified a prohibition on collecting payment from the patient or the plan if the physician applicant is ultimately not credentialed. There's no double dipping in this bill, Mr. Chairman. If the physician is not ultimately credentialed, the physician does not get paid on the service. Additionally, Mr. Chairman, the substitute exempts Medicare and Medicaid. In the week worth of conversation we've had with the health plans, we've identified a distinction between how Medicare fee-for-service handles its enrollment programs versus how the payment rules are applied to Medicare Advantage plans. This bill cleanly carves out Medicare and Medicaid from the provisions of this act. It applies to the state's commercial plans as well as the state's state employee health plan. And finally, Mr. Chairman, the bill does one technical thing and then one very substantive thing. Technically, the bill directs the Virginia Department of Health to update the MCHIP regulations, which govern health plans in this area. And then finally, most substantively, the bill makes clear that payment to the physician is only after credentialing. And this is the final point I'd like to stress, Mr. Chairman. Ultimately, what this bill says is if a health plan decides that it will place a provider into its provider network, then and only then is the health plan under obligation to pay the provider for the services rendered during the period that the credentialing application was pending. And we believe this is a very fair balance between paying providers for services rendered to patients while protecting health plans from not overpaying on services to an unqualified provider. We think the substitute addresses the concerns voiced to the committee. I appreciate the committee's time and attention on this. I'll yield to other speakers.
Okay.
Good afternoon, Mr. Chairman, members of the committee. Scott Johnson, General Counsel for the Medical Society. We very much support the substitute. And let me give you a real-world example. You hear about physician shortages. So suppose a physician group in your district is recruiting a new resident, say that resident's coming out of VCU to come back to your area. That physician group is going to identify that resident to come back in. They'll sign a contract with that resident to talk about, you have a license, here's your work schedule, here's what you're going to get paid. But until that physician is able to be credentialed by a health plan, they can't see your patients under what we have today. This bill will enable that physician, that new physician, to show the patient a notice saying, I've not been credentialed yet, but if you want me to see you, I will. And you don't owe me any money if I'm not ultimately credentialed by your plan. The same example would work if you had a physician coming in from another state and an expertise. That physician group would be able to recruit them in. There are safeguards out there. We're not trying to open the floodgates, but for that physician to practice here, they have to have their license by the Board of Medicine. The National Practitioner Data Bank tracks what's going on with that physician's past. And again, it's a patient choice. If your constituent, our patients, say, no, I don't want to be seen by that person, end of story. So with that, Mr. Chairman, I'm glad to answer any questions.
Senator Norman.
Thank you, Mr. Chairman. Under the current system, what would be an average period of time that it would take to verify the credentials?
Under the MCHIP regulations, which are governed by the Health Department, you have a period of time up to 120 days. The question often becomes is when the application to the insurance company becomes complete, because they have to verify a lot of information about the resident or that doctor, like where you worked, where you trained, that type of thing, and that takes a while to get it there. Once you get everything gathered, it's provided, and it can run the gamut from a period of weeks to a period of months, depending on how long the process takes on both ends.
Well, I appreciate,
Senator
Mr.
Norman.
Chairman, it depends on how long the process takes, but what would be an average period of time?
We have seen some situations
No,
where
what would be an average period of time?
I would say a fair average may be anywhere from 30 to 60 days. I can't give you one number, Mr. Chairman, because it varies between insurance companies. They're not all cookie cutter. Some companies may take the longer end of that spectrum, and some are more efficient and take a shorter end. It's not one number that I can represent to you.
Mr. Chairman,
Senator
one more
Norman.
question. Do you really think it is appropriate for the patient to be making the determination, or should there be some intervention by perhaps individuals that have a higher knowledge of experience and verification? Why put it on the patient?
Mr. Chairman, I would say, and I think the best patient example is always family. And I trust my wife's judgment. I trust my daughter's judgment. I trust my mother's judgment. They're a pretty good judge of their healthcare providers. And I think the public is able to make that decision.
Mr. Chairman,
Senator Norman.
trying not to be a lawyer here, Scott, but if in fact we've got a resident who is coming in who is unknown to the community, what have your mother and your father and your aunt and your sister got to do to credential this person?
I think the biggest thing they have is the fairness to ask that resident, what's been your training, what's been your experience? And while they're given a notice and said, I'm not credentialed, that person has got to have a comfort level with them. I mean, any patient that doesn't like who's caring for them has got the freedom to walk out. This bill's not going to change that. Thank you, Mr.
Scott,
Chairman.
I don't want to do a raise of hands in here about how many people walked into their doctor, and the first thing they said is, what is your credentials and what is your experience? I suspect there wouldn't be many hands go up, but,
You're right, Mr. Chairman. They would have to get that notice, and that would prompt that question.
okay. All right.
Thank you.
All right. Are there others who wish to speak in favor? Yes, sir.
Mr. Chairman, committee members, thank you. My name is Scott Gunn. I own two American Family Care urgent care clinics in the state of Virginia, one in Midlothian, one in Roanoke, and just wanted to briefly share our experience of where we've run into some issues during this process and ask for your support of the bill. The undefined time period now of the credentialing process gets stretched out, and when you have a new clinic that's opened up, it creates a pretty significant financial burden there, where you're potentially are seeing patients and not getting reimbursed for that. And this will allow, again, we're not asking that the insurance payers change their process of how they make the decision. We're just simply asking to be paid for the work we've done once that decision's made. The state of Tennessee passed a similar bill to this 2 years ago. And again, it gets in line with the government payers like Medicare and Medicaid for the retroactive billing. And it also in turns will lowers that time again, but we're not asking them to change the process of how they make their decision.
Thank you. All right, is there opposition to the bill?
Mr. Chairman, I'm Doug Gray, Executive Director of the Virginia Association of Health Plans. At the outset, I just want to remind you that philosophically, our members can support the idea of our members being sent to an uncredentialed provider. We don't think it's a good idea. We wouldn't send our family to an uncredentialed provider. If you all choose this approach, that's your choice, but we really can't philosophically support it. Secondly, the bill does the opposite of what we're required today. So Medicare and Medicaid require us to credential. There's no ifs, ands, or buts about it. VDH's regs require us to credential, and they say that we cannot pay or enter into a contract with the provider until we've credentialed. And that's why the bill has to exempt Medicare and Medicaid. That's also why the bill has to change the VDH regs. And so we're in good company in our position that philosophically it's not a good idea to expose our members to an uncredentialed physician. One observation I would share with you is if the plans had brought a bill to you to undo the credentialing process and just skip it, I think you would express concern about a danger to the public and not support that effort. So I would just share that observation with you that we're really in a position here where we're trying to do what we think is the right thing for our member. But that being said, the advocates and the committee have done a good job of at least letting us get to the core issues. And those core issues, as described by Hunter, have at least been substantively changed in the bill. There are 5 new items in the bill that address those substantive issues, but they don't address the overall substantive issue of philosophical nature, which is whether you expose someone to an uncredentialed provider. And what we're concerned about is an uncredentialed provider who comes from another state who might have a charge that wasn't adjudicated and isn't on their record pending. That's the type of thing that we get concerned about. But we've done what we can on this effort. So thank you for the opportunity.
Questions?
I also thought it would be good to comment on Senator Norman's question. The turnaround time for my largest member is 20 to 32 days.
Okay. Any questions for Mr. Gray? He doesn't want to take any. He's walking
Mr.
away.
Chairman, Mr. Chairman, I do have one.
Yep. See?
So, Mr. Chairman, so if under the system today, if a practice brought in a new doctor and they were seeing patients not credentialed, would they be able, once they got credentialing, would they be able to go back and bill for that time for any of the patients they saw before?
Excellent question, Mr. Chairman and Senator McDougall. Today, if you have a contract with a health plan and you have other providers, you can bill under another provider number. And so they immediately can collect payment as a practice. The issue here, which I think a previous speaker was alluding to, is what if I'm opening a new facility? Under this bill, if you're opening a new facility and you don't have a contract with the plan, you can't take advantage of this situation. You must be credentialed and have a contract with the plan to get paid. And you can't, under this arrangement, you can't really have a contract with the plan until you've been credentialed. So I don't know that it's going to solve the problem of a sole practice where there isn't a physician that hasn't been in business yet. But it could help with one that has a sole provider and that provider has left and they're trying to get another one. But a contract between the plan and the provider is necessary for payment to take place. So the short answer is yes, they can collect their payment today if they have a contract with the plan and other providers.
Yep. Okay, Delegate Head, you'd like to wrap up?
Yes, Mr. Chairman, just a couple of things. First of all, a provider can't be paid for services that were provided under somebody else's provider number. So what you just were told was, I think, at best a confusing way of stating that. I'll not try to use pejorative terms, although it is awfully tempting to do that. But we'll refrain from that in this setting. The other thing that you need to all keep in mind is that the term credentialing is what's being batted around here. And understand that an uncredentialed physician is not unlicensed. And the Board of Health Professions and Board of Medicine has already credentialed these folks. And they already possess the appropriate credentialing to provide care legally. The difference is that these health plans are dragging their feet, and the ultimate issue here is they don't want to have to pay the bill. It always comes down to money, because any way that they can delay or deny a claim is what insurance companies will always do. They've got to make a profit, and I understand that. But all this says is, once they've started the process, if they want to drag their feet, which they sometimes do, and we have reports, I have constituents that brought me this issue to begin with, that saw credentialing drag out anywhere not from the 22 days, but into the 90 to 120 days on a regular basis. And the estimates are that if you're seeing a regular number of patients a day, that can actually cost a practice on an individual physician somewhere close to $50,000 a month. So if that's goes on for just 90 days, you're talking about increasing the cost of that provider by about $150,000. All we're asking with this bill, all we're trying to accomplish with this, is that once the insurance company has gone through with the credentialing process, that they go back and pay for the services that they would have paid for to begin with, so that it really helps them to get off the dime. So, Mr. Chairman, that's the issue, and I appreciate your consideration.
Okay, committee operates by motion. Substitutes before us. It's been moved and that the substitute be reported. Clerk, open the rolls.
Seven ayes, 5 nays.
Thank you, Della.
Thank you, Mr. Chairman.
Bill's reported. Delegate Kilgore, you got a little bill for us today? All right.
These guys want to go in front of me, whatever the chairman wants to do. I have, Mr. Chairman, have House Bill 1558. 1558, which, Mr. Chairman, I have a substitute prepared which conforms this bill to your bill that passed the House 65-30 today.
That's what I understand. That's what I understand. Senator Norman motions and Senator Obenshain seconds that the substitute be adopted. All those in favor say aye. Any opposed? Okay, the bill's before us.
And now, Mr. Chairman, the bill in front of you addresses the double dip issue that was brought up in front of on both the Senate floor and the House committee. It also addresses some other issues concerning some of the processes by which the SEC could and would have regulatory oversight. And also it makes a lot of technical changes from the previous bill. It puts the 10-year sunset on the program regarding the underground transmission lines, makes clear that the use of the customer reinvestment credit is at the option of the utility, clarifies that the customer reinvestment credit may apply only to a portion of the total cost of the project, and also it ensures that the cost recovered through the base rates may not be used for a rate adjustment clause, provides for SEC prudency review prior to potential acquisition of renewable generation, and make sure that future overhead lines wouldn't be installed in the underground corridor there at Haymarket. There was some question about that, so we did fix that. I want to thank the governor's office for its help in this process and convening the work group. But all in all, it's basically, after those changes, it's the same bill that passed the Senate after we made those technical adjustments.
So by way of review, Delegate Kilgore, we're going to have a $133 million refund for in the Dominion service territory. this year and a 67 next year. Rates will be reduced starting 1 July, right?
Right, that's
Okay.
correct.
We still setting a goal of 4,500 megawatts of solar.
Right,
New
500
solar,
plus.
5,000 total.
500, yeah, that's
5,000
right.
total.
It's
Well,
5,000.
500 in place now, but okay.
Right.
All right, and allows a continuous stream to make investments in the grid, to update the grid.
Right.
And provide for smart meters and
Right.
and a smarter grid, right?
That's correct. And also the immediate pass-through of the tax relief.
Okay.
Starting July 1st.
And a whole list of people that support it,
A whole list of people that support it.
and a couple of people who were adversaries that are now take a neutral position with a smile.
Right. That's correct, Mr. Chairman.
I'm just being clairvoyant. I just wanted to check.
Right.
Okay. Are there any questions for the patron? Hearing none. Is there anyone opposed to this legislation? Hello.
Thank you, Mr. Chairman and members. Edward Petrini for the Virginia Committee for Fair Utility Rates and the Old Dominion Committee for Fair Utility Rates, groups of large industrial customers of Dominion and Appalachian Power, respectively. We continue to have serious concerns with HB 1558 because it does not restore the State Corporation Commission's authority to reduce excessive base rates and order refunds of excess earnings. The base rates of Dominion and Appalachian Power continue to collect revenues that significantly exceed their costs, plus a fair return. For example, the Commission's September report stated that Dominion's rates produce revenues in excess of its costs, plus a fair return, by $400 million in 2016 alone. Appalachian's rates also were excessive, but the amount was not as great for the smaller utility. Quite simply, the bill will cause the excess built into the utility's current base rates to continue into the future. That means customers will be required to pay hundreds of millions and billions of dollars in excessive rates. The bill's tight restrictions on the SCC's treatment of costs mean that today's customers will pay for the costs of serving tomorrow's customers. That is, customers that take service literally decades into the future. When regulators set rates, they try to avoid that. While rate making is never perfect, regulators try to match benefits and costs.
Excuse me, would you agree with me that the ratepayers, back when the nuclear power plants were first commissioned, bore the costs so that ratepayers in the future could take the advantages of those investments? Because the lowest form that Dominion has right now, short of their hydroelectric dams, is their nuclear power plants. So would you agree with me, based on that statement you just made, that the ratepayers of the past paid for those costs so that the ratepayers now could take advantage of those low costs? Would you agree with me on that one, based on the statements you just made?
I would agree that the ratepayers in the past and the ratepayers in the present have paid for the costs of the nuclear units. The way the rate making works, Mr. Chairman, is that when an investment in a new power plant is put into rate base, the company gets to earn a return on that investment. Over time, that investment depreciates. And every year, there is a fraction of that investment that's returned to the investors. So over time,
I understand.
that investment goes down. Now, as it happens with the nuclear plants, there have been a number of capital additions over the years that have been added to those plants to make them even more efficient and even more useful to customers. But those costs are spread over the entire useful life of the plant.
I understand.
And so what we don't do is allow the entire investment to be recovered in a year or 2 or 3 years. We allow those costs to be spread out over a period of time. And the rate base will be, for that particular plant, it will go up as that new plant comes into rate base. And as plants are retired, there'll be some reduction in
Well,
rate
now,
base.
now in your initial thing, you asserted that Dominion had over-earned by $400 million. Would you agree with me that based on that numbers, that the SCC didn't apply the 400 million, and what they did was arbitrarily said that 400 million is going to be spread over 10 years as opposed to being expensed off at one time, and that's how the SCC came up with that 400 million? Would you agree with me on that?
My understanding, Mr. Chairman, is that the 400 million is the approximate number for 2016 alone, and that it does not reflect a one-time write-off that Dominion had included on its books for 2016.
In other words, the SCC was going to spread that across.
That's correct. The 174 million roughly would be amortized. It would be recovered over a lengthy period of time. That was for
And even though Dominion had expensed it off, that's the assertion that the SCC made, and that's how they came up with 400 million. Would you agree with me on that?
That's correct, but I would suggest that it's more than an assertion. I mean, that's the normal way that capital additions or capital investments in a power plant are treated, sir. They're not written down immediately. A capital addition is amortized or recovered over the same period of time as the underlying asset.
I understand. I understand exactly what you're, go on.
I guess I was concluding by saying that the bill does not restore the State Corporation Commission's authority to regulate the base rates of Dominion and Appalachian, and that the significant excess revenues collected in the current base rates of Dominion and Appalachian will simply continue into the future. We continue to oppose the bill.
Okay.
Thank you.
Good afternoon, Mr. Chairman. Sam Towle, Deputy Attorney General from the Office of the Attorney General in his capacity as Consumer Counsel. I'd like to thank the patron and you, sir, for addressing the issue of double recovery that we believe has been adequately addressed in both the Senate and House versions of this bill. Unfortunately, our office continues to have reservations and must continue to oppose this piece of legislation for three reasons, many of which you have heard from the Virginia and Old Dominion committees. I don't want to belabor the point, sir, but it's three elements. First, the structure of the bill, we believe, is fundamentally designed to prevent any reduction to the base rate, which makes up about 60% of a customer's bill, over the course of the next decade. Second, as you heard, the accounting treatment that's provided for in the bill will restrict the State Corporation Commission in its ability to apply generally accepted accounting principles as they relate to regulated entities. And that third, this bill deems cost beneficial and prudent without evidentiary support a $2 billion project related to undergrounding. Those are our points. Does anybody have any questions? Thank you.
Any
Appreciate
questions?
it, Chairman.
Thank you. Yes, sir.
Good afternoon, Mr. Chairman, members of the committee. I'm Peter Anderson with Appalachian Voices. We oppose the bill as we have from the start. I want to thank all of you folks, the patrons, and all the stakeholders who have worked to improve this bill. We've seen a lot of improvements in this bill, including addressing of the double dip, and we appreciate that. The reason my organization still opposes this bill is that, well, we associate ourselves with the comments just made by the Office of Attorney General's Consumer Counsel, in particular the repeal of the reasonable and prudent authority of the SEC in Section 6.
Right, thank you.
Yep, thank you.
Yes, sir.
Thank you, Mr. Chairman and members of the committee. I'm Mitch King, representing Old Mill Power Company, an Albemarle County-based renewable energy company, and Luminaire Technologies, a Grayson County-based hydroelectric power producer. My concern with this bill is only one specific portion, Enactment Clause 11. I realize that this bill is the product of a stakeholder group that met for a series of weeks, but I will point out that there's an advantage and a disadvantage to or I should say a disadvantage and an advantage to not being invited to participate in that group. The disadvantage, of course, is that I haven't been able to influence the product. The advantage is I get to look at the product with a fresh set of eyes and get to tell you what I think is wrong with it. There's a lot to like in this bill. There's this energy share portion, for example, paid for by Dominion shareholders. There's an energy efficiency portion in the bill that the large general service customers are automatically exempted from. I'm sure they find that nice. And there are grid modernization projects, including underground transmission and distribution lines, which benefit all ratepayers. The problem I have with Enactment Clause 11 is that it provides a 2% rate cut for large general service customers, basically large industrials. It doesn't tell you this, but the way rate making works is if you give a 2% rate cut to one rate class, it automatically reduces the amount of money available for a potential refund to all the other rate classes, or causes the rates for those other rate classes to go up. So the practical effect of Enactment Clause 11 is that large industrial users are essentially subsidized by small businesses, residential customers, including low-income residential customers, and worship centers. So for that reason, I oppose the bill. In essence, what it's doing is it's asking a small business like the ones I'm representing to subsidize a rate cut for large industries, and that just doesn't make sense. I've distributed an email to you to that effect last week, met with either your staff or you personally on that subject, and that's my story. I'm going to stick to it.
Well, we must be doing something right, because you're complaining about rate cuts to large industrial customers, and the large industrial customers complaining it doesn't go far enough. So we're getting somewhere in the middle here, it sounds like. Thank you, Mitch. I appreciate it.
You're welcome.
Thank you. Yes, sir.
Mr. Chairman, I'm not here to oppose the bill as such. I'm here to offer a friendly recommendation. My name is John Quapis, and I'm here on behalf of myself and my family, but also in a larger sense on behalf of all Virginians, because what I suggest is an issue that is critically important, affects all Virginians in the future, their well-being and possibly their very lives. Now, the bill's name is the Grid Transformation and Security Act. That's a good bill, but unfortunately, the security aspect of this bill is rather weak, very weak indeed. There's vague references to, and I think a few places to hardening. There's some references to physical security being improved. But that's it. There's no conscientious attention focused on the issue of grid security. And today, the greatest existential threat that faces this country is the threat of attack on our national electrical grid by way of a nuclear electromagnetic pulse attack, which now is understood to require only one nuclear weapon at a certain height, at proper height over the country, which can basically wipe out the entire electric grid in the nation and all the facilities and industries and businesses that relate to that, as well as most of their electronics. The Federal EMP Commission estimated that this event, if it occurred, would kill within a year's time 2/3 to 90% of the American people would die. Now, Russia and China already have this capability. North Korea is apparently very close to having it, if not already having it, and Iran is a few years away. Beyond that, we face cyber attack. Cyber warfare is ongoing from Russia and China against our grid and other facilities, and against, and also North Korea is involved as well. The other thing that is of significance is a solar geomagnetic event, which is a solar storm that can hit the Earth and basically do the same thing, destroy all the electronics, which cannot basically be replaced in any significant time. This nation, this planet, narrowly missed that kind of a giant solar magnetic storm back in 2012 by 9 days, And if it was estimated that if we actually had been in the time frame of our Earth orbit in the right position 9 days earlier, billions of people would have died within a year's time. So this is a threat that can occur, and there's increasing danger with the hostile countries. one other thing, Congressman Brad, I talked to him about this issue. He's quite familiar. He told me that he talked with the members of the Joint Chiefs of Staff at the Pentagon, the top military, and that they told him that the issue that they're most worried about facing this country is an EMP attack. That is the most direct and dangerous thing for this country's future. Most military bases are protected against such an attack, military equipment. In fact, Mr. Chairman, I understand you helped to outfit 3 Navy warships against the EMP attack. But the public infrastructure, water systems, sewage, transportation, communications, and all this are not protected at all, and the grid is not protected. Congress has passed a law to begin the work on this issue, the Critical Infrastructure Protection Act. And that will be, in about a year or two, will be coming down with regulations and requirements via FERC for utilities around the nation to begin to do the work to do this. Now, I've proposed.
Senator Saslow.
Let me ask you a question. You had said earlier that one nuclear bomb at the right place at the right time, and that China and the Soviet Union have such a capability, delivery capability. And we, over the last 35, 40, well, actually even more than that, have been developing a launch detection system, which was done originally with what's called over-the-horizon radar, and where we had equipment in various parts of the Earth that could detect a launch. Now it's done by satellite. Do you really think that if a nuclear war was started by Russia or China, that they would just fire one bomb? I think you know better, and you know what the answer is.
Of course.
Right,
the threat is really not from Russia or China because we maintain deterrence against those two countries. The threat is from the rogue nations.
Well, but here's the point. In order for a successful attack, you probably would have to fire a lot more because us, as well as 1 or 2 other companies, have developed a pretty good anti-missile system. Now, that missile system, if only one is fired, that won't work for the country that's firing it. They probably have to fire close to 100. And then we would knock down probably 80%, but the 20% that would get through, believe you me, shortage of electricity would be the least of our problems.
With all due respect, sir, I spent 5 years in the 80s working and promoting the Strategic Defense Initiative system to build an anti-missile defense against such a threat. That system has not been built. It is marginally produced at this point. The capabilities of that system are very limited at this point. The military recognizes it. The House Armed Services Committee recognizes that fact. And it does not take hundreds. It takes a missile launched off a freighter, which has been studied by the EMP Threat Commission.
Okay, all right, I'm going to get this thing back on track. I didn't want to put the timer on. This is not the Armed Services Committee in Washington.
But there are 3
sir,
amendments.
Please wrap up because we still have to hear that. And I still have a whole big agenda ahead of me right now.
I appreciate your patience. Thank you. Very quickly, I did propose, and I think all of you have received a copy of it. I do have additional copies here of 3 amendments that would help to address this issue. One provides grid security analysis and proposal reports required of all utilities that would look at the vulnerability, basically inventory the vulnerability of their systems, the facilities and the grid. Secondly, it would have them develop draft proposals to begin to protect all those facilities. And it would also have a subpart which would be a near-term proposal that would do the most critical elements of it that are also some of the cheaper and easier things to do. Those are proposals that would be required of them to put together that information. The second proposal would take 10% of the money that would be going as credits back to the customers via the utilities, and say a utility could take up to 10% of that money and use it towards the planning and development and implementation of some of these security measures. The third amendment is a demonstration project that would actually provide one utility, one system of electrical generation in an area, and have that system, what's authorized to do it, it doesn't provide the money at this point, but to do it and make it seriously hardened and protected, a very full-scale effort to make this system protected. And hopefully that would be done for the Richmond area. I think that
Okay.
would be useful for all of us.
All right, well, thank you, sir. We need to hear from the proponents of the bill. Thank you so
Okay,
much for
thank
coming.
you,
We
but please
appreciate your
consider this
testimony.
for next year, the
Thank you,
minimum.
thank you, please. Okay, are there those in favor of the bill? Briefly.
Mr. Chairman, John Rust for Dominion. Dominion does support the bill.
Thank you.
Mr. Chairman, Brett Vassy, Virginia Manufacturers Association, we support the bill.
Thank you.
Mr. Chairman, DeJuan Robinson with the Natural Resources Defense Council. We also support the bill.
Thanks, Dwayne.
Chairman Scott McGrady of Washington Gas, we support the bill.
Okay, thank you.
Afternoon, Mr. Chairman, members of the committee. Matt Strickler, Secretary of Natural Resources. The Governor's Office supports the bill.
Thanks, Matt.
Mr. Chairman, Mike Town, Virginia LCV, we support the bill.
Thanks, Mike.
Mr. Chairman, Ryan Dunn, Virginia Chamber of Commerce. We also support the bill.
Thanks, Matt.
Mr. Chairman, Hayes Fromme, Orsted, we're the largest offshore wind developer in the world. We support the bill.
Thank you.
Mr. Chairman, Josh Levy, Northern Virginia Technology Council, also in support of the bill.
Thank you, Josh.
Mr. Chairman, Mike Forehand, Northern Virginia Chamber of Commerce. We support the bill.
Thank you.
Thank you.
Okay, committee operates by motion. You don't need to wrap up. We got it. Okay, it's been moved and seconded that 960, House Bill 1558, amendment in nature substitute, be reported. Clerk, open the roll. Okay, report the bill.
11 ayes, 3 nays.
All right, thanks. Thank you, Delegate Kilgore.
Mr. Chairman, I have some other bills, but if
Oh,
you want
let's-
to take
let's
some
do
of
them
these,
all.
if you would like to take some of these,
Absolutely,
folks who
let's
have
do 'em.
only one bill, I've got 3 bills left, so.
Okay, all right.
I'll hang around.
You want to hang around? Okay, next on the list, Delegate Sullivan. Can I have a copy?
I usually start by thanking the committee, but I should thank Delegate Kilgore first, right?
All right.
Good afternoon,
What do you
Mr.
got?
Chairman, members of the committee. This is HB 1451, which is a bill, so Section 1 bill, I guess there is a substitute, which we send around.
It's been moved and seconded, substitute be agreed to. All those in favor say aye. Any opposed? Okay, the substitute's before us.
Thank you, Mr. Chairman. What 1451 is designed to do is to help local school systems save money and incentivize the creation of energy-efficient, zero-energy schools. I'm quite proud to stand before you and say that the bill is supported by both Dominion Energy and the Sierra Club. It was inspired by a school in my district called the Discovery School, which is a zero-energy school, which means that in any given year, it will produce more energy than it consumes. The bill creates a pilot program that, of course, will include Discovery School, but also any other school systems that can and want to be involved, which would create a situation in which when a school is zero energy like the Discovery School is, it would be allowed over any billing period to credit electricity that exceeds and it is put back onto the system, that to either the school system as a whole's bill or Dominion would just write a check. That is not currently what's allowed to happen. Now, just to hang some numbers on this, Mr. Chairman, over the first 3 years of the operation of the Discovery School, the expectation is that it will return about 300,000 kilowatts of energy onto the grid. And as the system currently works, Arlington will receive no credit or payment for that 300,000 kilowatts. So what this does is set up a pilot program. It requires the SCC to develop the rules of the road. It requires Dominion to report to us, the General Assembly, annually after this gets started to see how it's going and hopefully create a situation in which other school systems will be able to participate and look to construct schools like this one, which is, as I said, zero energy. Good for everybody.
Okay, so you're setting up a net metering energy program for the school
Correct.
system. Okay. Any questions for the patron? Anyone opposed to the legislation?
I move to report, Mr. Chairman.
Been moved and seconded that the amendment in nature substitute to House Bill 1451 be reported. Clerk, open the rolls. Okay.
13 ayes, 0 nays.
Okay, that bill's supported.
Thank you, Mr.
Anything
Chairman,
else?
members of the committee.
Okay. Next, Delegate Poindexter.
Mr. Chairman, members of the committee, House Bill 1270.
1270.
Straightforward, not complicated. The bill really states that would require that the governor, any state agency, boards, political subdivisions would not be allowed to establish a cap and trade system for CO2, or any government, the governor, state agency, political subdivision, may not participate in a regional CO2 organization such as RGGI. However, but or if such proposal were brought to us, you, in the House, the General Assembly, then as long as the General Assembly had a vote on such proposal, such could be implemented. Mr. Chairman, I bring this bill because of the criticality of energy to all of us, its reliability, availability, and cost in our homes, business, hospitals, schools, law enforcement, and everywhere else. And I would argue that the people's representatives are the proper place to embark on such type programs, especially in light of the legislature and governor's role in regulating our utility companies.
Okay, questions? Pretty straightforward. Okay, I imagine there are those that would oppose this bill, so start lining up. And we'll take proponents afterwards.
Chairman Wagner, members of the committee, Bob Shippey from the Sierra Club. We oppose this bill. If you don't like Reggie, you can vote against the Reggie bill, which the body already has done. I don't think we need a bill that says we just can't even move forward no matter what. Thank you.
Okay, thank you. No, Michael.
Mike Town, Virginia LCV, we oppose the bill.
Thank you.
Afternoon, Mr. Chairman, members of the committee. Matt Strickler again, the Governor's Office, Secretary of Natural Resources. Governor Northam believes that this legislation moves in the wrong direction. He thinks Reggie and certainly regulations to reduce carbon pollution are in the benefit of Virginians, so he opposes the bill.
Matt, if I could ask you, stop right there. There's one thing about carbon regulation and reducing carbon output. There's quite another thing about multi-jurisdictional, multi-state initiatives to do that, bound by a set of regulations not created in Virginia and
Yes,
bound
sir.
by a set of trade program. Does the governor distinguish the difference between those two?
Yes, sir.
He does, but he still opposes this bill.
Correct. We've had our legislation to link to Reggie to become a full member to Reggie. That obviously was defeated here and defeated in the House, but we don't think that this legislation moves us in a positive direction either.
Okay, thank you.
Thank you.
Mr. Chairman, members of the committee, Harrison Wiles with the Chesapeake Climate Action Network, and we oppose this legislation and believe that cap and trade will move us in the right direction as far as public health and protecting our climate.
Yeah, thank you.
Mr. Chairman, members of the committee, my name is Kevin Maurer, Virginia Catholic Conference. We also support, oppose the bill for the reasons already stated. Thank you.
Thank you.
Thank you, Walton Shepard with the Natural Resources Defense Council. 2 votes ago, this committee voted to modernize the grid to reduce long-term overall costs. We think this bill would actually be one step in obstructing the ability to do that in one particular way, so we would ask you to oppose this bill.
Okay, thank you.
Thank you.
All right. Are there those in favor of the bill?
Mr. Chairman, members of the committee, Ryan Dunn with the Virginia Chamber of Commerce. We support the legislation. We can talk about Reggie and whether we like it or against it, but this bill simply puts the power of energy policy where it correctly belongs and protects that stays here at the General Assembly. This bill just says that a state agency and a governor cannot agree and go into these terms. So we have long supported, even under the Clean Power Plan, we stood before you and said that energy policy is made at the General Assembly, and we want to make sure that it stays there. For that reason, we support it. Thank you.
Thank you. Appreciate it.
Mr. Chairman, Brett Vassy, President and CEO of the Virginia Manufacturers Association. We support this bill. We want to give you a few pieces of information because we know that there are politics involved in this, not just the science, but we think the science is important. Virginia, without Reggie, has reduced over the last number of years, I think it's about 6, our CO2 emissions from 38.4 million tons to 33.9 million tons. And we really don't know, forecasting what we've just done with the senator and the delegates' bills on 5,000 megawatts of renewable, how much further that will be done. Our point in this is there is a differentiation, to the chairman's point of view, between RGGI, which is a tax scheme, and between carbon reduction, which is a goal. And in particular, if you just look at some of the reports on RGGI, about 13% of that money has been spent on absolutely nothing to do with reducing greenhouse gas emissions or environmental controls. That's about $175 million. The last thing I want to share with you is when you look at the cost in the northeastern states, their prices for industrial power are nearly double what ours are. We think that over the course of the next few months, working with the administration, with the carbon regulation that we're about to embark upon through the administrative process, you will see a path that will be state-based and regulatory in nature, and then this body would be the most appropriate body to make a judgment on how to go forward, but RGGI is not it.
Thank you.
Thank you, Mr. Chairman. Just a couple points to close. I'm very concerned about the allowances that occur in these cap and trade and RGGI type schemes. That money goes somewhere, and someone, not us, decides on where it is spent and how it's spent. RGGI in particular, Virginia is not in good company with the rates, as the previous speaker said. They raised the rates in the Northeast range from about 16 cents per kilowatt hour to $21.20. That's a huge difference. So, but the real purpose of the bill is to make sure that we, the legislature, the people's representatives, get a cut at it.
Okay. I think everybody understands the bill. Senator Cosgrove.
Thank you. We've been bad-mouthing Reggie a lot. Can we hear from Reggie and see what he has to say about that?
Okay. All right. I think everybody understands the bill. We've heard from both sides. Committee operates by motion. Been moved and seconded that House Bill 1270 be reported. Clerk, open the rolls.
Eleven ayes, 4 nays.
Okay. Thank you, Delegate.
Thank you, Mr. Chairman.
Appreciate
Members
it.
committed.
Delegate Hope.
Thank you, Mr. Chairman. Members of the committee, you have House Bill 234.
House Bill 234.
This bill was brought to me originally by the Virginia Pharmacists Associations. What House Bill 234 would do is it would allow health plan enrollees to synchronize their medications so that they can order and receive them on the same day each month instead of having to make multiple visits to the pharmacy. When this has been done in other parts of the state, and just so you know, in the federal rules, regulations, they allow it for Medicare Part D participants. This results in a reduction of poor health care outcomes that result from the lack of medication adherence. In other words, people actually take their medications with this policy. And so that's what the bill does before you.
Are there questions for the patron? Is there anyone opposed to this bill? I just made 4 trips to the pharmacy. Explain to me why this is a bad bill.
Mr. Chairman, members of the committee, Jody Roth on behalf of Virginia Association of Chain Drugstores. We had originally supported this bill in its original form. However, with the House amendment, our members find that there's confusion and potential interpretation of this bill, and they would love to have more time in the off-season to work with key stakeholders to ensure more adherence for patients and their medications and being able to sync them up more than once a year. So therefore, we do oppose it in its current form now.
Okay, thank you.
Mr. Chairman, Alexander McCauley representing Epic Pharmacies, and this is the combined co-op for independent community pharmacies in the state. I wasn't going to testify until I heard the testimony from the chains, but we very much support the bill, think it's been a well thought out, well crafted bill, and hope you will vote it out of here.
Thank you. We're hearing from all sides, okay?
Mr. Chairman, members of the committee, I'm Kyle Shreve with the Virginia Association of Health Plans. Just to clarify, on line 23, I believe is where we're talking, provided that such a proration for any prescription. So this allows for, it ties it to the prescription for once a year and not to the covered person. So if something changes, they would be allowed to sync the new prescription if something did change. Thank you very much.
Thank you. Okay, is there anyone else? I see the Nature Conservancy up there. No? Okay. All right.
Maybe
Commi-
Reggie
Committee
will-
operates by motion. Been moved and seconded that the bill be reported. Clerk, open the rolls.
14 ayes, 0 nays.
That bill's reported. Thank you.
Chairman.
Okay, Delegate Bolova. Delegate Bolova is not here. Delegate Boysko. Did I pronounce that properly? All right. Welcome.
Thank you so much. So we are moving to a whole different issue. HB 1087 is on animal research. I have been working with the stakeholders, and today I have an amendment to offer before we get started.
Clerk, if you'd report the amendment.
Mr. Chairman, the amendment, there are two amendments actually. Page 1, line 47 of the bill. The first change would be after section 321, comma, strike the or, and then after biomedical products, insert comma, or any other products regulated by the U.S. Food and Drug Administration, except for any products regulated under subchapter 6 of the Federal Food, Drug, and Cosmetics Act, 21 U.S.C. section 301 et sec.
Okay.
Great, thank you.
Is there a motion on the amendment? Been moved and seconded that the amendment be adopted. All those in favor say aye. Any opposed? Okay, Delegate Boysko.
Thank you so much, Mr. Chair.
What are we trying to do here?
This bill will prohibit the use of animals in non-medical testing when modern non-animal methods are available. Historically, animals have been used in painful tests to assess the safety of chemicals used in many products, including cosmetics, household cleaners, etc. Ingredients may be force-fed to animals, dripped in their eyes, or rubbed onto their bare skin for extended periods of time. But with innovations in science, the suffering of animals is no longer needed for development and testing of many products. Alternatives to animal testing are available using engineered three-dimensional human skin tissues or other types of cells in sophisticated computer models. Alternatives that are cheaper, faster, and can better predict human reactions are already widely available and being used. In 3 other states, they've enacted similar legislation over the past 10 years and have demonstrated that giving priority to non-animal tests is cost-efficient, effective, and promotes scientific advancement. The European Union has required that scientifically satisfactory non-animal tests had to be used ahead of animal tests since 1986, and we believe that Virginia can lead the way to ensure that animal tests are not needlessly harmed in these outdated tests.
Okay. There are questions for the patron? Seeing none, is there anyone?
Chairman.
Senator
Just a
Overseen.
quick question. I know that Senator Sturdivant, Senator Stanley had a bill earlier that I think just met its demise today in the House that dealt with painful animal testing. Is this for painful animal testing or all animal testing?
This is for all animal
That's what
testing,
I thought.
but it accepts medical. So it accepts it, and this went through unanimously through the House. Okay, well.
Exempts medical.
Mr. Chairman?
Yeah, Senator Stewart.
Delegate, does this potentially have any effect on any of the, and I don't know the answer to this question, so that's why I want to ask you, on any of our research universities and their ability to do what they're doing or what they might want to do going forward?
On anything dealing with the medical field, it does not.
Mr. Chairman?
Senator Stewart.
I'm not sure that was my question. Does this affect any of our institutions of higher learning in Virginia that do research? Will it affect them going forward? Or any partnerships they want to establish, or any work that they might want to do?
Sure. I actually have some people who can testify on the bill. I do understand that folks were contacted in the various universities and nobody had any opposition to it.
Okay, Senator Stewart. Did you have something, Senator Overseen? Okay, is there anyone in support of the bill? Yes, sir.
Thank you, Mr. Chairman, members of the committee. My name's Chris Hyde with Cruelty Free International. And I think to address your question, there was, I think, the impact statement, the study out of the House following the bill passage said that there could be, but we have not been able to identify if there is anybody that's actually doing cosmetics testing within universities. It's usually would be done with contracting, private contracting firms. But I think that was their finding, but there were no actual cases or any evidence that it has been an issue.
All right. Thank you. Are there others in support of the bill? Wow.
Mr. Chairman, Brett Vassy.
Craft brewers in favor of it, or the manufacturers?
Manufacturers today. Mr. Chairman, the amendment we have worked on over the last 3 weeks with the patron. We want to thank her for working with us. We needed absolute clarity that our FDA-regulated and controlled facilities would remain FDA-controlled and regulated with absolute clarity. There'd be no two different standards. So that's what this amendment does. We are satisfied with the bill, and we have no objections any longer.
Okay. All right, we have the bill before us as amended. Is there a motion on the bill?
Mr. Chairman, just one question. One question.
Yeah, Senator Cosgrove.
Thank you. Mr. Chairman, I'd ask, is there anybody from Virginia Higher Ed here, or Chev, or anybody from the universities that can answer the questions that were asked about the universities? Yeah, all right. Guess not.
Okay. All right. Senator Overchain.
I tell you, I don't know enough about the non-medical testing, but I am troubled by the painful medical testing and thought that we had a pretty effective vehicle for addressing that. Now, I would suggest that we conform this to Senate Bill 28 and report.
Second.
Okay. It's been moved and seconded that we conform House Bill 1201 to Senate Bill 28.
Mr. Chairman,
Yeah.
this is actually a different bill.
It might not be.
Its intent is different.
We have a motion to conform.
This,
we have a motion properly supported to conform the bill. Clerk, open the rolls on this one. Okay.
9 ayes, 6 nays.
9 ayes, 6 nays. The bill is conformed. Okay.
Sir, Glenn, you want to make a motion?
Committee operates by motion. Okay, it's moved and seconded that House Bill 1201 be reported. Clerk, open the rolls.
Fifteen ayes, 0 nays.
Senator Boy Scott Levy with one message, and it may not be your problem, but we learned in physics to every reaction there's an equal and opposite reaction. So you might discuss that with some of your House patrons on that, and you might be an innocent victim of that law of physics, okay?
well, whatever we can do to reduce pain on animals. so
Thank you.
Thank you.
Okay, next, Delegate Klein.
Yes, sir. Yes, sir. Yikes. Senator, good afternoon.
Oh, good.
House Bill 1201.
Okay. Okay, it's all yours.
Mr. Chairman, this would authorize out-of-state.
What bill are we on now?
1201.
1201.
Mr. Chairman? Yes, sir. This would authorize any out-of-state health insurer to sell individual or group policies in the Commonwealth if it's approved in the out-of-state insurer's home state. It establishes requirements, registration with the SEC, and establishes requirements applicable to such sales, including registration disclosures, compliance with marketing standards, and financial condition. It's similar to an initiative the President is taking at the federal level for group policies, but because individual policies were not affected, this is a step to kind of match up the opportunities for consumers who are not seeing options in their health insurance market to purchase out-of-state plans, if some can be found.
Okay, the questions for the patron. pretty straightforward bill. Are those opposed to the bill?
The health insurers are opposed to the bill,
As
Mr.
of-
Chairman.
of
There he
course,
is.
How are you?
See, I was going to have your back.
Mr. Chairman, members of the committee, Kyle Shreve with the Virginia Association of Health Plans. This is a similar bill that you saw earlier in the session. We do oppose it, we just would like to remind everybody that all the mandated benefits and all the consumer protections that you have here in Virginia would no longer be required to follow for an out-of-state. It puts my members at a particular disadvantage to those that are outside the state in, say, Iowa or Wyoming or anywhere else that you could find a license to come and sell insurance. For those reasons, we oppose the bill. Thank you.
Okay. Delegate Klein, do you have those in support of the bill? Besides yourself?
Yes, sir.
Okay, you don't. Okay, questions for the patron? Seeing none, committee operates by motion. Been moved and seconded that House Bill 1201 be reported. Clerk, open the rolls.
Eleven ayes, 3 nays.
Okay, that bill's reported. Delegate
Thank you,
Klein,
Mr.
you got
Chairman.
anything else?
No,
Nope.
Your Honor.
Okay,
Mr.
Delegate Hugo. What's that? Okay, did Delegate Bulova show up? Okay, Delegate Jones. Welcome.
Good afternoon, Mr. Chairman, members of the committee.
What do you have for us?
House Bill 1368.
House Bill 1368. Okay.
Yeah, this bill is basically aligning Virginia's mini COBRA program with the federal program, which basically says if an employee is discharged for gross misconduct, that they are prohibited from buying back onto the employer's health plan. And this came about from a legal matter that I handled in which my client had to offer the discharged employee health care coverage on their plan for a year the employee to buy back after the employee had stolen all of their client information and start a rival company. So we brought this up to align our mini provisions with the 20 employees and under with what the larger businesses already have.
Okay, questions for the patron? Okay, committee operates. Is there anyone opposed to this legislation? Seeing none. Been moved and seconded that bill be reported. House Bill 1368. Clerk, open the rolls. Okay. That bill's reported.
13 ayes, 0 nays.
Thank you, Mr. Chairman.
Okay. And Delegate Kilgore,
I think I've waited everybody out.
you got your newsletter ready? Can we all read it?
I've got it. I've got it.
We're looking forward to reading it.
I quoted Senator Chafin a couple times.
Oh, now I'm not looking forward to reading it.
No, you're
Okay.
not looking
All
forward to
right.
reading it. Right.
What do you got for us? What's
I
left?
have a couple bills. One is House Bill 1258, and I think there's a substitute on that.
Okay,
Frank.
motion on a substitute? Been moved and seconded that the substitute to House Bill 1258 be adopted. All those in favor say aye. Any opposed? Okay, the bill's before us.
Mr. Chairman, members of the committee, this is, I think, the same bill that Senator McDougal presented in the Senate dealing with advancing Virginia's wireless and broadband technology by examining and approving the approval process. And basically, it establishes a statewide approval process for structures that are under 50 feet high. It preserves localities' jurisdiction over historic sites. It puts in place a predictable approval process timeline, limits application reviews to issues that are relevant to land use, and creates some opportunities for applicants to cure deficiencies. Mr. Chairman, this also, with the amendments, it addressed some concerns. I think that Fairfax, with the amendments and substitute, addressed some of the concerns that Fairfax County had. We put in on the first page, line 17, public, and put in some on page 4, on line 92, the cost basis for the fee. And some on page 6, line 132, required that it be supported by substantial record evidence containing a written record
publicly released within 30 days following disapproval. So we have worked on this process, tried to address some of the concerns, and also I think there is a new amendment which should replace the enactment clause on page 9. Is that correct?
Yeah, clerk, if you could report the amendment to the substitute.
Mr. Chairman, it's on page 9 of the substitute on line 215 after 2. Repeal the rest of the language on line 215 and all of 216 through 219 and insert the following. And some copies are being distributed, but I'll read it anyway. That any publicly owned or privately owned wireless service provider operating within the Commonwealth or serving residents of the Commonwealth shall, by January 1, 2019, and annually thereafter until January 1, 2025, provide to the Department of Housing and Community Development a report detailing by county, city, and town enhanced service capacity in previously served areas and expansion of service in previously unserved geographic areas that are provided access to wireless service.
Okay, that's just to provide a better, more detailed report. Is that the purpose of that?
And that's
Okay.
correct. And to also give the localities a report on where that they are expecting to be served and things of that nature and what they've been working on.
Okay, is there a motion on that amendment? But moved and seconded that amendment be adopted. All those in favor say aye. Any opposed? Okay, that amendment's before us. Senator McDougal, you're working similar legislation in the House. Are you okay with what's going on here?
We like it.
We like it. Okay. All right, let's see if there's anybody who doesn't like it. Whoa.
I've tried.
Oh, wait a minute.
How you doing? Hey. So, Mr. Chairman, Chris Costa with Fairfax County. I'm an assistant county attorney. I got to tell you, I've not had a chance to review the whole substitute, but I don't know of any. I want to make sure the county is opposed to the bill. As far as I can see, the substitute, we're still opposed to the substitute. I want to make sure that it wasn't just represented that we weren't opposed to this substitute. That's right. So, and we're still talking. I just had a conversation this morning to still work on this bill right now. So, the big problems that we have are the administrative process removes the community from any kind of public hearing or any other public process to be able to talk about the siting of towers that meet the administrative process criteria. For those towers that don't meet the administrative process criteria, there are still a bunch of restrictions on what localities can do before they can disapprove an application, some of which I think swallow the rule. One of the things says that we shall not disapprove an application, line 144, based on an applicant's business decision. We have no interest in getting into how people make their own business decisions. That's fine. But isn't everything in an application, quote unquote, a business decision? If I see a circuit court judge and try and explain that to them, they're going to say that's everything under the sun in an application, including the land use impacts, which are what we're concerned about. So there are still some major problems, if you will, with the way that we would be able to interpret and understand those parts of this bill. The last thing is, we have a problem with undergrounding in certain areas. We don't believe that we meet any of the protections for the undergrounding that are included in this bill, and that means that all of those there are areas where we've required undergrounding for the purposes of economic development to create an environment where people will want to create businesses, where jobs will come in, where people will want to come and live and work and play, all in the same area, so to speak, and that'll all be often transit related. When you look at some of the undergrounded protections inside this bill, we don't meet the protections that are there, so that these structures will then could potentially populate the cityscape, which we already have other things in the cityscape itself as well. And there's no guarantee that we're going to be able to disapprove those structures under the terms of the bill as it is right now. So if anyone wants to ask me, as I've seemed to have heard time and time again, can't you still disapprove under this? This is much less likely that we'll be able to disapprove anything in that regard, even though it may have significant visual and aesthetic impacts in the community themselves. Thank you.
Okay, thank you. Yes, ma'am.
Mr. Chairman, Michelle Gowdy, Virginia Municipal League. For all the reasons that Chris Costa has mentioned, we oppose the bill. In addition to that, though, I want to tell you that we've had numerous localities do resolutions and send letters from small towns as Galax and Round Hill to Chesapeake and Virginia Beach, because they really don't like this bill. They want their citizens to have the ability to shape their communities. And so we would just ask that you consider all of those resolutions and letters that you've received from the localities and how frustrated they are about this bill. Thank you.
Thank you.
Mr. Chairman, Joe Lurch with the Virginia Association of Counties, also for the same reasons in opposition to the bill. Thank you.
Thank you very much.
Mr. Chairman, committee members, my name is Leighton Powell, and I'm with Scenic Virginia, and we oppose this bill as well.
Thank you.
Mr. Chairman, members of the committee, I'm Laura Bateman on behalf of Prince William County, who is opposed to any diminishment of local government land use authority, and for that reason opposes the bill.
Thank you.
Thanks.
Good afternoon, Mr. Chairman. Morgan Whalen with the City of Norfolk, and we oppose this bill, and our council has unanimously passed a resolution against this. Thank you.
Mr. Chairman, members of the committee, Bob Mathias, City of Virginia Beach. We are still opposed to this bill. There's been quite a bit of discussion that opposition to this bill is going to keep broadband, 5G, whatever, from being expanded in underserved areas. We're not trying to stand in the way of that, but it's obviously clear that business decisions are going to be made at where this technology is going to be expended. They're not going to put it into underserved areas where there are very few customers. There is a paragraph, an enactment clause at the end of the bill says the report will be done on how much underserved area is covered in the future, but there's no consequences if there's no extension to underserved areas. Thank you very much.
Thank you.
Mr. Chairman, my name is Pat Calvert. I'm representing Virginia Conservation Network, and we oppose this bill as written.
Thank you. Okay, those in support.
Good afternoon, Mr. Chairman. My name is Rick Cornwell. I'm with Verizon, but I also led the industry team that has worked on this through the legislative work groups, 2 of them now, over the last 2 years. I won't repeat everything I told you when we heard the Senate version of this bill, but I'm going to summarize quickly in repeating what I did say in the fact that every locality can deny an application if they give us a reason for the denial. 2, it protects historic sites. 3, it protects undergrounded areas. But what is failed to be told to you every time we have one of the opposition members stand up and talk to you is that your constituents, they want the service. Even the localities themselves want the service. They just want it on 138 different terms. It makes it difficult to attract the capital to this state to do the work that needs to be done when other states have passed similar legislation that makes it more competitive to attract those capital dollars. I hope that you will support the legislation and pass it. Thank you.
Thank you.
Mr. Chairman, Michelle Painter with Sprint. I also was on the working group for the last couple of years, and I support what Mr. Cornwell said, and Sprint supports the bill.
Thank you.
Afternoon, Mr. Chairman, members of the committee. Chris White, Vector Corporation, here on behalf of T-Mobile. We support the bill.
Thank you.
Thank you.
Mr. Chairman, Vince Apperzage with AT&T. This will lead to more investment in Virginia, and we support the bill.
Thank you.
Mr. Chairman, members of the committee, Durant Walton, representing the Virginia Telecom Industry Association. My wireline companies support this bill.
Thank you.
Mr. Chairman, members of the committee, Rebecca Gunn with the Roanoke Regional Chamber. We do support measures to localize or standardize local zoning processes and make it more efficient for providers to be able to expand our markets and meet our underserved and unserved communities. Thank you.
Thank you.
Mr. Chair, members of the committee, Mike Forehand, Northern Virginia Chamber of Commerce. We do support the bill. Thank you.
Thank you.
Mr. Chairman, Josh Levy, Northern Virginia Technology Council, also spent the past 2 years on the work group and very much support this legislation.
Thank you.
Mr. Chairman, Chris Kyle, Shintel, we service exclusively rural areas. This bill will help us deploy our wireless network in Virginia in these rural communities. We support the bill.
Thank you so much.
Mr. Chairman, members of the committee, Ryan Dunn, Virginia Chamber of Commerce. We also support the legislation, looking for a statewide approach, looking for that unified approach to make things easier. And at the end of the day, this is not just going to benefit the underserved, but is going to actually help those who are unserved, which is a very important population. Thank you.
Thank you. Okay. I think everybody understands the bill.
Mr. Chairman?
Senator Black.
Just a comment, if I could.
Absolutely.
It is very difficult to, have all the local government up, and I know how local government feels about the bill. But at the same time, what I've seen over the last 15, 20 years is local government is kind of like a ping pong ball because, you know, on one hand, people come in and they'll say, oh, don't build these towers. And then the next thing, you got another group that comes out and they say, we don't have any service, and what are you doing? How come you people are not doing your job? And I understand. I mean, I sympathize and I understand where local government is and the pressures on you from both directions. But at the same time, I think we just reached a point. I mean, we've been going through this. I think we just got to do something and get on with it. So I'm going to support the bill.
Okay, Senator Saslaw has a question for
Okay.
Delegate Kilgore.
Delegate Kilgore,
Yes.
you said, I thought I heard you correctly, you said an amendment that satisfied the problem that Fairfax
No,
County.
had set, addressed some of their concerns, but they're still against the bill. We tried to address some of their concerns.
What's left that they're concerned with? You're telling me that, because I've heard this all along, that
Yeah.
they can turn down an application.
That's,
Any application or just
no,
certain types of applications?
it's my understanding they can turn down any application if I've, let me get Rick back over here.
Because this is important to
Line
resolve.
213 and 214 of the bill.
Nothing.
Last two lines of the bill.
It says nothing shall prohibit
I
a
don't have a copy
locality
here.
from limiting the number of new structures or the number of wireless facilities that can be installed in a specific location.
Where is-
Uh,
Which line?
The last two lines of the bill,
the
before the reenactment
enactment clause?
Before the reenactment
Before the
clause.
reenactment.
213 and 214 maybe?
Nothing in this article shall prohibit a locality from limiting the number of new structures or the number of wireless facilities that can be installed in specific locations. So suppose they said none.
That would be up to the locality, then they'd have to deal with their citizens.
I gotta tell you, he's making sense.
Yeah, so, okay. We say none. What do you think's going to happen, Mr. Chairman?
Well,
Senator
you complied
Saslaw?
with the bill as I read it.
Senator Saslaw.
We would not be complying with federal law. Federal law says we are not allowed to deny any application if the effect of that denial prohibits service. So we have to comply with federal law to allow some. If we allowed, and of course we're going to allow them, we embrace it. We don't have a problem in Fairfax County with, we've already approved 125 towers, and we've approved just before last year's small cell bill, we were already approving close to 100, I believe it was around 80, what they call DAS nodes, small nodes that go on top of poles that are similar to these small cell facilities they're telling us that we'll get with 5G in a few years, but are not close to being deployed. We don't have a problem with approvals in our county. We don't like having applications come in with the idea that we're supposed to deny them. We don't want to deny applications. But what this bill does is it stops us from being able to try and get to yes, where we balance, as Senator Black alluded to, the community's valid concerns about what things are going to look like where they are, and the industry's need and our need for economic development to get their service in there. And we mediate those claims, and we have been very successful at it so far. And so what we would like to do is to not have the restrictions in this bill so that our hands are going to be tied in that negotiation, and the community is going to come out and say, how did this happen, where a structure comes in, and we're going to point to this bill and say it's because we don't have the authority to negotiate like we could before, to ask companies to do the things. The idea of limiting the number in a specific location, in addition to the federal law, let me give you a for instance. July 1, 2018 comes around and this bill is now law. We say on a particular block, we're going to have 4 structures. 5 applications come in relatively at the same time and they're all pending. Which of those applications are we supposed to deny on the grounds that, we're only allowing 4 in there? We're not going to pick a winner and a loser like that.
That's what's called life.
Well, I appreciate that.
And, you make those decisions just like we make decisions here every day for 60 days. And, if the people in that, if they don't like it, believe me, they'll let you know. But it says, it's pretty clear in here, nothing in this article shall prohibit a locality from limiting the number of new structures or the number of wireless facilities that can be installed in a specific location. We can't make up your mind for you on which of the 5, one of the 5 you're going to reject.
So, again, if it comes, I'm sorry, Mr. Chairman, if I may. So if, Mr. Chairman, Senator Sasslaw, if it comes under the administrative process, we have almost, I don't know how we're going to be able to deny something if it meets all the administrative criteria, regardless of whether or not we've limited the number. And then again, the idea is that to say that we can limit the number, I find under the practically speaking, is not particularly meaningful for us. That's all. So, I mean, they can say it in the bill, but again, if it comes under the administrative process or if it comes under this, even the regular zoning process, and we start saying reasons why we're going to deny, and they're going to say we can't use that reason under this bill because it's a business decision or our service design or whatever it is, when we're talking about visual impacts and co-location, and we're going to have debates about that sort of stuff. And of course, we're going to want to get to yes, and we're not going to want to end up in court. So,
Okay. All right.
So what you wanted, instead of.
Senator Sasslaw.
Mr. Chairman,
Yeah.
instead of limiting, you wanted the word rejecting. Is that what you wanted? Does that make you in favor of the bill?
I don't know if that means that we can, that all the rest of the bill gets swallowed up, but that would be fine. But I mean, yeah, I mean, I've spoken with them this morning.
Talk to the sponsor.
I've continued to speak with the representatives I've been told to speak with, and we've been working, and I'm waiting to hear back now. That's the posture that I'm in.
Well, you still got floor, man.
Senator Sasslaw.
All right.
All right,
No,
all right,
I'm done.
all right. All right, I think we got it. We got the amendment in nature substitute as amended. Committee operates by motion. Been moved and seconded that the amendment in nature substitute as amended be reported. Clerk, open the rolls.
Thank you, Mr. Chairman.
Thank you.
15 ayes, 0 nays, one
I've
abstention.
got two more, but these.
Oh, they're here now.
These two
Okay,
guys.
two more. Let's do Delegate Boulevard. He's got a subcommittee meeting.
I
Delegate
still got
Boulevard.
two more. Go ahead, they're quick.
They want total control. What you got, Delegate Boulevard?
Thank you, Mr. Chairman. And by the way, I thought your SEC questions earlier on got more and more interesting every time we heard them. So,
Well, thank you.
anyways,
Okay.
House Bill 922. Sorry, it's a while ago. House Bill 922, with the exception
Little
of
grease, you never know. Okay,
Yeah.
Delegate Boulevard, go on.
with a small amendment that I believe council has is identical to Senator McClellan's Senate Bill 908, which has passed both the House and the Senate. What it does is it simply authorizes localities, colleges and universities, and our state parks to put in fee-based electric vehicle charging stations.
Sure. You good with the amendment?
Yes.
Clerk, report the amendment.
The amendment's on line 46, after owned, insert or leased.
Okay, is there a motion on that amendment? It's been moved and seconded that amendment be agreed to. All those in favor say aye. Aye. Any opposed? Okay, is there anyone opposed to this legislation? Seeing none, been moved and seconded that House Bill 922 as amended be reported. Clerk, open the rolls. Okay, that bill's been reported. Thank you,
Thank you,
Delegate
Mr. Chairman.
Baldwin.
14
Delegate
ayes, 0
Hugo.
nays.
You wanted everybody to go. Okay.
Hey, Mr. Chairman, House Bill 1233.
Yep. House Bill 1243.
33, I believe. 33.
1233. Okay. All yours.
Hey, Mr. Chairman, thank you. Hey, look, I've got 4 kids, and I hope they all go to college. But, you know, some kids don't want to go to college, and we've got to try to find some different paths and to help these kids along. One of the things that we've tried to do is look at the apprentice program. If you look at some of these jobs, kids will come out, go through an apprentice program, they'll be making $80,000 to $100,000. And they'll be a pipe fitter, a welder, electrician, go to the shipyard, whatever it may be. What we're finding, some of these kids are coming out of college, and they end up going back to working at making $20,000, $25,000 at retail. These are real opportunities here. So what we've tried to do here, Mr. Chairman, is try to find a way to encourage additional apprenticeships. What we found, though, in Virginia, they prevent from having one journeyman to having even 2 apprentices. What this bill would do was just allow to have 2 apprentices per journeyman. One of the things we looked at, Mr. Chairman, what's happening around the country. Michigan, a highly unionized state, has 3-to-1. North Carolina allows more. Minnesota allows 2-to-1, mostly in electrical. West Virginia, 3-to-1. Iowa, 3-to-1. Nebraska, 3-to-1. North Dakota, 3-to-1. Utah, 3-to-1. What we're simply asking is 2 to 1. Try to get more kids in this. What we found, I've even talked to some of these young men and women, one of them went to UVA, found they didn't really like it, and then went to an apprentice program, and they got a great degree, I think, in art history at UVA, and now they're apprentice, working, I think, at one of the shipyards. It's a real opportunity. If you look up in my area, and y'all know, sometimes they think, oh my gosh, he's not going to college. Well, that kid not going to college is sometimes making a lot more if you go through an apprentice program, become a journeyman, than the kid who went to college. This just allows people to have these other opportunities. It's something we hope will make it, we think, is kind of a common sense way to approach. And one of the things you may hear is they worry about safety issues. I understand that. You know, I grew up putting in heating and air conditioning, working at the shipyard, things like this. Not the good shipyard you had, but another one, and working at that one. And you want safety, but one of the things that we've gone through this process, at least in the House side, we've said there's been no data to show that there's a problem in safety at 2 to 1. We're not asking 4 to 1 or 5 to 1. Like a lot of states do 3 to 1, simply 2 to 1. So we think this is a safe mechanism to get more young men and women in the apprentice program, because, you know, I just had dinner 2 weeks ago with the chairman of the Transportation Committee in Congress. They're pretty sure we're going to have a transportation bill move through the House and Senate this year on the president's desk. So with that, Mr. Chairman, I appreciate y'all taking the time. I think there's a few people who want to testify, probably for and against, but I appreciate y'all taking the time to listen to me today.
Thank you, Delegate Hugo. Okay, let's hear the opposition first. Yes, sir.
Hello, sir. Hello, Senators, Chairman. First of all, I know state of Maryland just voted on the 2 to 1 ratio and turned it down. So I don't know about the other states that Mr. Hugo talked about, but I know Maryland chose to vote that down. My name's David Geib. I'm an elevator apprentice for 4 years, mechanic for 33 years. I represent 1,200 elevator mechanics and apprentices. Hundreds of them are your constituents. I'm here today to strongly oppose this bill, and there's basically 4 reasons. 31, 31, 42, 35. That's not the pick 4 on Saturday. That's the 4 previous years' deaths, job site deaths in Virginia alone. 31 in 2014, 31 in 2015, 42 2016, 35 in 2017. Those are the facts from the Department of Labor, state of Virginia. The sad thing is, somebody gets shot on the street corner, it's in the news today. Somebody gets mugged on a train, it's in the news today. A person loses their life on the job site, you never hear about it. I don't quite understand why that is. They're workers. They're our brothers and sisters and nephews and all that. So that is basically, sadly enough, an average of about 1 death on a job site in Virginia about every 10 days. Amazing, but you don't hear about it. Here today, we are talking about the increase in the responsibility of a mechanic to supervise not just 1 young adult, but now 2. I gave you the numbers. I'd like to have a couple of names with those numbers. I lost my mechanic, Kevin Quinn. He fell 17 floors. He alone has to represent himself and make sure he's safe, much less take care of the apprentices. Mark Schiller, a friend of mine, he fell 11 floors and died. This is all in Virginia. Ron Zimbro, he got caught up in the shivs and the cables, and after 8 hours of dismantling the elevator, we were able to get him out of the building. That just happened 5 years ago in Reston, Virginia. Nobody probably heard about it. We formed a line as the EMTs escorted him out. Joe Oliver, he lasted 12 years in school. I went to the funeral for him. His parents had a picture by the casket, same picture I have on my wall, of my child with all the years of school in a circle, and then his cap and gown. That was right by the casket. He lasted 7 months as he fell 3 stories. Think about what we're doing here. I've talked to Mr. Hugo. I know we can move forward with positive apprenticeship goals, and we can set forth those goals safely. This is not the answer to this. and I really would hope that you don't pass this bill.
Mr. Chairman?
Thank you.
Senator Black.
Just a quick question. I'm very sympathetic towards these folks. I've been a factory worker myself. And, but the names that you mentioned, these are under a system where we're one-to-one.
Yes.
So isn't it really that, industry, industrial, factory work, there are some inherent dangers. Are you sure that is all just the supervision, or isn't it just sort of the nature of the business to some extent?
Sadly enough, it is the nature of the business. Building trades is terrible. The elevator trade ourselves, we have 7 fatalities a year. Unacceptable. We're one-to-one. It's still unacceptable. We have safety. It would be Otis Elevator. Some of the big people or just the smaller companies, they have safety implementations all the time. It's just inherent, and that's why we're asking you not to put 2 young kids in a supervisory position with 1 mechanic that has to take care of himself also, and then take care of those young folks. We have a big push to keep these kids safe in school, right? Let's keep them safe after school.
Okay, I'm going to ask the next, unless you got a line up behind you, and we're running out of time here. So be brief. If you have additional things you'd like to add, please do, but please be brief.
Thank you, Mr. Chairman. Ian Hines with the Keystone Mountain Lakes Regional Council of Carpenters, and we oppose this bill.
Thank you.
Vance Ayers, constituent in Virginia. Senator Stewart's my senator. I've been a tradesman for 20 years. And what I'd like to add to is I'm an elevator constructor by trade also. 10-to-1, we don't want to make it worse by having less skilled people out on the job. Like we said, supervisory stuff, it's still not acceptable. We don't want to make it more acceptable. So, is it life or money? And the reality is there's a shortage of apprentices in the United States of America, all over the country, because the kids don't come to work. They don't want to apply for the positions. So anybody to say that apprentices are trying to get into this profession and can't, they're wrong, and I can show you all kinds of stats about that. So there's no shortage of us opening our books and trying to pull kids into the trades. They're not getting into the trades. So this thing to give more people opportunity is false. So that's reality.
Thank you very much. Yes, sir.
Mr. Chairman, John Rayner. I represent the iron workers, and although I applaud the senator's desire to increase apprenticeship, I'm all for that. I was an apprentice myself. I think it's a bad bill due to the fact that it does put economics in front of safety, and we just cannot have that. Iron working is one of the most dangerous trades there is, and all the building trades, my colleagues will yield to that. And so when I drive over the Wilson Bridge, I know the bridge is not going to collapse because it was built by journeymen with the assistance of apprentices. When I take the rail over the Silver Line, over the Beltway on the Silver Line, I know that bridge will not collapse because it was built by journeymen with the assistance of apprenticeship. But we cannot have a situation where it's in peril that a journeyman be responsible for 2 apprentices. And that's just a buyer safety concern.
Thank you, sir. Yes, sir.
Good afternoon, Mr. Chairman, members of the committee. My name is Felix Shapiro. I'm here on behalf of the Northam administration. While we also share a commitment to apprenticeship programs and feel there have been fruitful conversations on the topic, we're afraid we cannot support the bill due to concerns about safety and quality of training.
Thank you.
Thank you very much.
Sure. Yes, sir.
Chris Pagali, I'm with the Pipe Fitters Union. Thank you, Mr. Chairman and committee, for having me. I also had a big, long prepared speech here to talk about safety. I think everybody knows about the safety issue of it. I've worked around apprentices for the last 30 years. Never seen the ratio at 1-to-1. I got an outstanding education, and so do all my members. They're not working 1-to-1. Also, on line 24, they have apprentice here, and it says means a person at least 16 years of age. I'd like to remind the committee that a person 16 years of age can't pick up a power tool, and that's a federal safety law and an OSHA regulation. So I'd like you all to consider that and not pass the bill.
Thank you.
Thank you.
Yes, sir.
Hello, I'm Mark Farley with Keystone Mountain Lakes Regional Council of Carpenters Chair Committee. Just want to remind y'all, we stated it is a dangerous profession that we do. So when we take on training, we're not in a safe classroom. We have a lot of hazards. Just want to minimize bad opportunities that could arise. Oppose this bill. Thank you.
Thank you. Yes, sir.
Mr. Chairman, my name is Mike Briley. I'm the business agent for Local 110 in Norfolk, Virginia, plumbers and pipe fitters. I served an apprenticeship program. As one of the members just stated, it's pretty rough as far as getting an apprenticeship ratio as it is as we speak now. I don't think Virginia is up to the 1-to-1 as we speak as far as all crafts are concerned. When you put a journeyman with more than one apprentice, you run not only the hazard of contaminating your water systems, steam lines, very dangerous. So I'd like to go on record to state we oppose this bill.
Thank you. Yes, sir.
Good afternoon, Mr. Chair. Thank you for the opportunity to speak. My name is Matt Yonka, President of the Virginia State Building Trades. I'll be very brief. Obviously, my colleagues have covered just about everything. I would like to point out one statistic, but first I'd like to thank Delegate Hugo for his efforts. I understand what he's trying to do and would love to work with him further on trying to enhance programs like our apprenticeship programs. However, the state of Virginia currently has 13,000 registered apprentices approximately. There are over 300,000 registered state licensed journeymen in our state. It represents roughly a 23 journeyman to 1 apprentice status right now. The problem with that is that we do have the opportunities and availability there to increase apprentices in all of our programs. I think there's a loss right now in the educational process of showing young people that there are career alternatives out there as opposed to college or community college, that they could have a lucrative career. For the safety aspects and everything that was previously stated, the Virginia State Building Trades opposes this bill. Thank you.
Thank you. Any others? Are there those in support of the bill?
Mr. Chairman, my name's Ed Dalrymple. I'm president of Schmung Contracting in Cedar Mountain Stone. At those companies, we operate 8 apprentice programs right now, and we work with the Department of Labor and the community college system. Those apprentices work with mentors that see them go through the program. This would help us put additional apprentices on. The ones that we have in place right now work full-time for us, have a very specific line of duties that they'll perform while they're at work. They'll go to college on weekends and on nights and end up with an associate's degree when they're completed. The apprentices are an average age of 31. There are people that are coming out of the military, need additional training. There are people that decided to come and decided not to work in retail and come into our business. It's in the asphalt apprenticeship program under industrial maintenance, electricians, and mechanics programs.
Thank you.
Thank you. The average age is 31, and an average wage of, they start out at 35,000 and go to about 85,000.
Thank you.
Mr. Chairman, members of the committee, Ryan Dunn with the Virginia Chamber of Commerce. By allowing more flexibility in the ratio, employers will be able to hire, train, and retain more apprentice employees, spurring growth in a much-needed skilled labor, and provide more opportunities for apprentices to enter the workforce. That's the reason we're supporting this bill. We understand there are concerns about safety. Even though if you look at other states, Louisiana has no ratio. You look at North Carolina, it's 2-to-1. The electricians in West Virginia, it's 3-to-1. There is no evidence that safety concerns or safety issues have been worse in those states where apprenticeship ratios are higher. The apprenticeship also goes well beyond the building and trades. It includes things like barbers, land surveyors, high-tech industry, a lot of industries that aren't inherently dangerous, where a 2-to-1 ratio would really benefit an employer. So for those reasons, we support the measure. Thank you.
Thank you.
Mr. Chairman, members of the committee, Nicole Riley representing National Federation of Independent Business. For our small business owners in particular, finding good qualified workers is now one of their top 3 problems that they've faced over the last 6 months. Many of them have talked to me about the fact that it's about getting good apprenticeships. We feel this bill will make it easier for them to be able to do that. When you have if you're a small business and you have a very small workforce, something like this where you could have 2 apprentices to 1 would be a big help. Thank you.
Thank you.
Mr. Chair, members of the committee, Mike Forehand, Northern Virginia Chamber of Commerce. We feel this bill is consistent with our view of supporting workforce development programs and non-degree attainment programs. So for that reason, we support the bill.
Thank you.
Thank you, sir.
Mr. Chairman, members of the committee, Chris West, representing Opportunity Solutions Project. I'll be brief and just say we associate our comments with those of the Chamber and NFIB and support this legislation.
Thank you.
Last, Julia Carlo Hammond on behalf of Associated Builders and Contractors, Virginia chapter. We support the bill as well.
Thank you.
Mr. Chairman, thank you. Both sides, I won't take much time. Thank you for hearing this. You know, I've worked HVAC. I worked with my friend Steve Ballard, you know, for construction, concrete, poured concrete, shipyard, warehouse. I've done sandblasting. I've seen people get hurt, and you don't want anybody hurt. The one thing I would ask you for the folks that testified, everybody that talked about safety, they didn't offer one government report. They didn't offer one industry report. They just said it's a safety issue. What I'm saying is we've asked if there's any government report that says all these other states that are doing 2 to 3 to 1, let me know. And we've never seen it. Never seen it. So I think we all have concern for safety, but what I'm saying is it is dangerous. Y'all have been seeing this. These can be dangerous jobs, but what we're proposing does not increase the level of danger. And if it did, either the government, some government entity in one of these states, or federal government, OSHA, or somebody would have reported it. And if nobody offered that testimony here today. Thank you, Mr. Chairman.
Thank you.
I'll be very
Mr.
gracious
Chairman?
with your time.
Yes.
Ask a quick question.
Senator Stewart.
Tim, I
Yes, sir.
don't profess to understand this. I've done a lot of construction myself in my younger days, and but if what you're doing is you're allowing the ratio to go from 2 to 1. It's not a mandate as I read that.
Right,
Is that
it allows
correct?
it, right. Right now, there's a prohibition that goes 1 to 2.
Right. So this just says you can have 2 to 1.
Yes, sir.
If as a practical matter, I guess the contractor makes that decision that's going to be 2 to 1. But if the journeyman says I can't handle but 1,
I would think.
is anybody going to force him to take 2?
I think they're going to do it. Administrator.
I would think as a matter of liability, they wouldn't,
I
but,
think they would.
so I look at this more as they're allowing the ones who want to allow them to have 2, but if you don't want more than 2, I can't imagine anybody's gonna make it, because they'd be liable if somebody got hurt.
Again, Mr. Chairman, I read off the multiple states that have 3 to 1 and 2 to 1. And they've seen fit, and many of them have not gone back. And I think, again, what I'm trying to do is get more people in these programs, especially in our area, Northern Virginia, Hampton Roads, where we need these young men and women, so. I
Okay.
won't belabor the point.
All right,
Thank y'all.
I think we understand the issue.
Mr. Chairman, this just happens to be something that I know just a little bit about.
Senator Lucas.
Yes, sir. I'm gonna date myself here. But right out of high school, I started an apprenticeship program at the Norfolk Naval Shipyard as an apprentice shipfitter, and I also did welding, as you know. And I just cannot imagine, if you're talking about the building trades, that a journeyman would have to have more than 1 apprentice. As I listen to the broad range of positions that you're talking about, if you're a barber, yeah, maybe you can handle 2 apprentices. Maybe if you're in cosmetology, you can handle 2 apprentices. But if you're working somewhere down at the shipyard, like when John McCain crashed his plane into the USS Forrestal, it was my class that helped rebuild that port sponsor on that ship. I cannot imagine that a journeyman could handle more than 1 apprentice on a job like that. So I think a lot of it might have to do with the trades that you're talking about. Well, but when you're talking about the building trades, my answer would be, I don't think I could vote for this.
Okay. Committee operates by motion.
Move the bill be PBI.
I got 2 simultaneous. I got a motion to PBI and a motion to reporter. Is there a second on the motion to report?
Second.
All right, it's been moved.
On which one?
Is there a second on, wow, you can make a substitute motion. I have a motion to report that's been properly reported. Is there a substitute motion? Senator Lucas, did you have a substitute motion?
Yes, I had a PBI.
You have a substitute motion to pass by indefinitely. Is there a second on that motion? Okay, it's been moved and seconded that the bill be passed by indefinitely. Clerk, open the rolls. Okay, that motion fails. Okay, we're back to the primary motion, and that motion is to report. Clerk, open the rolls.
Ten ayes, 5 nays.
Okay, that bill's reported.
Thank
Thank
you all. I
you.
appreciate your time. Thank you all.
Mr. Chairman,
Yes.
having voted on the prevailing side by which we reported House Bill 1201, I move to reconsider that vote.
Okay, it's been moved and seconded that House Bill 1201 be reconsidered. Clerk, open the rolls. Okay, the bill's back in the committee.
And the patron's not here, so
Okay,
maybe if
we
we
may
can
have to
pass
have
it
one
by.
more meeting real quick. Pass by.
I still have a couple more.
Don't worry about it. It's just reconsidered. Delegate Kilgore.
All right, now I'm back. House Bill 1486, Mr. Chairman.
1486.
This is dealing with assessments for long-term care insurance written by impaired or insolvent insurers. When there's an impaired or insolvent insurers, the insurance community comes together to take care of that issue. And this comes to us from the National Association of Insurance Commissioners. And this is the Model Act. And basically what this measure requires is that 50% of the assessments be allocated to the accident and health insurance and 50% be allocated to the life and annuity insurers. And that's basically what the bill does. There's I know there's a lot of people for this. There's a couple of groups that are against it, but I think the majority that are in this area are for this particular bill. But this is just sets up the methodology in case there is an insolvent insurer that's doing these long-term care insurance in Virginia. And you know, with the way that market is, that's a possibility. So that's why this
Okay.
bill's before you.
All right, let's hear from, does everybody understand the bill? Are there questions for the patron? Let's hear from the opponents first.
The opponents, okay.
Mr. Chair, members of the committee, my name is Jeff Palmore. I'm here on behalf of Kaiser Permanente. On behalf of Kaiser and its members, we respectfully oppose the legislation in its current form. This legislation addresses the issue of long-term care insurance, as Chairman Kilgore mentioned, potential insolvencies and who will pay for those insolvencies. The proponents' solution to the problem, as reflected in this legislation, is to force HMOs into the Guarantee Association and pay for long-term care insolvencies, despite the fact that HMOs do not write long-term care insurance. We write zero long-term care insurance, but our customers will be required to pay if long-term care insurance companies go bust. This legislation is not an industry compromise. Far from it. This legislation is the product of private negotiations between big insurers and life insurers, conversations in which HMOs were not included. This compromise was then heavily lobbied through the NAIC process. No other states have adopted this approach. Virginia would be the first state to adopt this legislation. Despite its length, the legislation only does two things. First, it sets a split between life and health insurance companies as to who's going to pay for long-term care insurance insolvencies to 50% life and 50% health. Second, it pulls HMOs into the Life and Health Guarantee Association. Because this is about long-term care insurance, it's important to know who writes long-term care insurance and compare how much they're asked to pay under this bill. Life insurance companies write 75% of long-term care insurance nationally. This legislation requires them to cover only 50% of the insolvency costs. On the other hand, health insurers nationally write only 18% of long-term care insurance. Yet this legislation asks them to pay for 50% of insolvencies. The current law that you can see on line 714 of the bill requires that assessments be allocated in a fair and reasonable manner. The new law would say that assessments are fair and reasonable except for long-term care insurance assessments. Why would you need an exemption from the fair and reasonable provision? Because the alternative presented in this bill is unfair and unreasonable. This legislation is essentially asking the health insurance industry to subsidize the business decisions of life insurance companies. So why did health insurers, who you're about to hear, say they support this bill, health insurers and life insurers, support this if they pay a disproportionate amount? The answer is that the big insurers are okay with it because by pulling HMOs in, they lower the costs of their assessments. If they can drag HMOs in, they pay less. We pay millions more, they pay millions less. And that's the portion of the bill to which we are most opposed, dealing with HMOs. This legislation is particularly unfair to Virginians with HMOs. A commercial health insurer doesn't actually pay for an assessment. In a sense, the taxpayers are paying for the cost of their assessment. The commercial insurer provides the money up front and are paid back over the next 10 years through tax write-offs and lower payments to the Commonwealth, yielding in reduced payments to the general fund. For that insurer, it's more of an accounting issue than an actual payment. HMOs, on the other hand, must pass these assessments on to our members in the form of a rate surcharge provided in the legislation. This results in higher costs for HMO coverage in Virginia at a time when health insurance costs are already increasing at alarming rates. These potential increases are not pennies, as you may hear from the supporters of this legislation very shortly. If Kaiser had been subject to the most recent insolvency, our members would have paid $6.7 million in additional premium payments, meaning several dollars to each member in add-on charges per month. Each Kaiser member would have been responsible for $45 in assessments. This is $45 additional dollars that would have come out of the pockets of hardworking Virginians. For what? To pay for a long-term care insurance insolvency. And why is that Virginian singled out? Because they get their care from an HMO, and for no other reason. What will the cost of future insolvencies be to Virginians with an HMO? We don't know. If there's more than one insolvencies, these costs could multiply. This legislation essentially asks Virginians with an HMO to write a blank check. Additionally, individuals and small businesses would be hit the hardest by this legislation. Medicare, Medicaid, and self-insured markets are exempt from this assessment. As a result, the fully insured, small group, and individual markets would carry the bulk of the burden.
Mr. Chairman, are you going to have other speakers? Because I noticed you let one person take up all the time, then you rush everybody else. I want to hear some other comments if there are other speakers. That's why I asked them.
Well, no, I think he's the only speaker.
There may be others saying that they oppose the bill, but I'm the primary opponent.
Thank you.
So because the Medicare, Medicaid, and self-insured markets are exempt, the fully insured small group and individual markets carry the bulk of the burden. For Kaiser, that's a large part of our business, so it would hit our customers particularly hard. For many Virginians, an HMO is their only option. If you're on the exchange and you live in places like Chesapeake, Suffolk, Harrisonburg, James City County, Williamsburg, King George, Spotsylvania, Virginia Beach, an HMO is your only option on the exchange. And this legislation will result in higher health care costs for the people in those areas. We've heard a lot this session about the increasing cost of health care and the exploding costs of insurance on the exchange. This committee has been the epicenter of some of those efforts designed to lower the cost of health care insurance in Virginia. Here's one bill that goes the opposite direction and will increase the cost of health care. How much will it be? We don't know. BOI hasn't had that opportunity to determine what the impacts of this legislation will be. This legislation also removes some language in our code designed to protect HMO customers in a hasty attempt to get this legislation passed. Currently, if an HMO goes insolvent, the other carriers pick up that customer and provide them coverage. But this bill removes all that language in a hasty attempt to bring HMOs into the long-term, into the Life and Health Guarantee Association. Is this the best approach? Is it better for them to receive a check versus continued coverage? We don't know. This wasn't in the NAIC Model Act. BOI hasn't had the chance to evaluate its impact. There's no good argument for removing this other than to rush to get HMOs in the association. If you're determined to move this legislation out, there's a solution. I would encourage you to first ask for an evaluation of the impact of this on HMOs, but the 50-50 portion of the legislation can move forward. If the life and health industries want to decide on an allocation ratio and adopt a 50-50 share, that's fine. That part of this legislation can move forward and function on its own. But please evaluate the impact on HMO customers before rushing to require them to pay for long-term care insurance insolvencies. Wrapping up, the NAIC made very clear that every state's market and laws dealing with HMOs is different. They recommended that states consider this their individual market when taking into account the unique aspects of every state's markets and laws. They expected each state to evaluate the legislation in the context of the state's insurance market. This legislation has not done that. It's a hasty cut and paste job without looking at what it will do to Virginians. We should ask BOI to study its impact before imposing these additional costs on HMOs. To be clear, Kaiser is not asking to be exempt and is not opposed to paying a fair share towards future insolvencies. But the legislation before you requires the health insurance market, and particularly HMOs, to pay a disproportionate share of the assessments for the cost of long-term care insurance that we don't write. We shouldn't place this burden on HMOs without examining the alternatives and the impacts on Virginians and their personal budgets. I encourage you to ask the BOI to examine the HMO piece of this legislation before adopting it. Thank you very much.
Thank you. Scott, just tell us who you're with and if you oppose it.
Yes, sir. I'm General Counsel for the Medical Society of Virginia, and we oppose it. And if I may just have one sentence,
Sure.
Mr. Chairman. The American Medical Association had weighed in on this issue nationally back in October. And when the physicians, approximately 600 at Kaiser, brought this issue to us, we reached back out to the AMA and said, basically, why did you do that? And they're like, well, we weren't considering a Kaiser-type model, which in essence is a closed model where they're employing the physicians, providing the health insurance and the coverage. And so the AMA agreed that the Medical Society of Virginia's position in opposition on behalf of those physicians who work in Kaiser is appropriate.
Okay, thank you.
Thank you.
All right, let's hear from the proponents.
Mr. Chairman, members of the committee, Reggie Jones. I'm representing, in this case, the Virginia Association of Health Plans, but also the American Council of Life Insurers, who are in total agreement about the fact that this bill is here to protect the Virginia policyholders, to make this fund that we have in Virginia, Virginia Health Life and Health Guarantee Fund, operate on a much more equitable and sound basis. This is an adoption of a model act that the National Association of Insurance Commissioners adopted in December after a year-long study. And the National Association of Insurance Commissioners realized we've got a potential problem of long-term care insurance in America, and we've already had one insolvency, Penn Treaty in Pennsylvania, a $4.2 billion hit on guarantee funds, and the Virginia Guarantee Fund had to assume about 10% of that $4.2 billion loss. And that assessment was done on a 75% to the health insurance plans, 25% to the life insurance companies. Well, the life insurance companies are the ones who've written the lion's share of the long-term care insurance. So the life insurers and the health insurers got together and said, we got to find a much more equitable way of handling this fund and to make sure that the state funds are solvent and in good shape. And in doing that, they agreed that life insurance side, they would assume 25% additional share, so there would be a 50-50 split between the life and health companies when the next insolvency comes along, if it does. This was adopted by the NAIC, National Association of Insurance Commissioners, with only one state commissioner opposing it, and that was Washington State. In drafting this bill, we tried to do everything we could to follow the model act from the National Association of Insurance Commissioners to adapt that to the Virginia chapter on the Guarantee Fund. And I worked with the Bureau of Insurance, the Virginia Life Accident and Sickness Guarantee Association's counsel, Alan Goolsby, along with representatives from life and health insurance companies. The model act is designed to make this a safe and sound guarantee fund, but also to try to get this balance back to 50-50 and make it more equitable. It does reduce the assessment for the health insurance companies, which is a good thing. And it means that the health insurance companies will not be stressed by the amount that they have to pay into this if there is an insolvency. Now, when we talk about HMOs, keep in mind what my good friend Jeff is saying is, he's speaking of HMOs like as HMOs versus the other insurance carriers, the health insurance plans. It is the non-profit HMOs. There are a lot of HMOs that are being brought under this who are in total agreement to be brought under it. In fact, one HMO, one health insurer who is going to be brought under this probably has more HMO enrollees than Kaiser. But they are agreeing that this is a fair and equitable way for this to be handled. And by our calculation, if you took the Penn Treaty loss of $4.2 billion and what was assessed to Virginia, if Kaiser Permanente had been at that time under this current law that we're hoping you will pass, their cost per member per month would have been approximately 30 cents per member per month if you spread it over the same period of time that the for-profit commercial plans have to spread their recovery, their recoupment through the taxes that they pay. So if you, the way they set it up in the NAIC Model Act is if you pay taxes, you can recoup it over 10 years. If you do not pay taxes, if you're not for profit, then you can recoup it by a surcharge on your premiums. And we believe if you take the numbers that Jeff used, I believe that would be probably 40 to 45 cents per member per month. Our numbers may differ, but conceptually it's not that much. I think here that the real issue is between whether you're for-profit or not for-profit. If we believe that the for-profit HMOs are fully supportive of this, even though they're being brought under this with a lot more cost to them, the not-for-profit HMOs would like to be carved out, and they're saying it because they didn't write long-term care insurance. Neither did the for-profit HMOs, the for-profit insurance plans, or the HMOs that I represent. Listen, both, Kaiser's an excellent HMO. We think they do great work, and we feel, though, that it's just not fair or equitable not to include them because there's very little difference today between an HMO and a PPO. And what is gained by this is, he mentioned the state plan for assessing in the event an HMO becomes insolvent. Well, let me tell you the history on that. The State Guarantee Fund, which we have a very good guarantee fund in Virginia, was established in 1976. In 1980 was when HMOs were developed in Virginia state law. But it was not until about 1988 that we had an insolvency of an HMO. So in 1989, we established an assessment here in Virginia so that if one HMO goes under, all this supporting that are the other HMOs, a very thin, narrow support. What will happen now under this act is that the HMOs will have the protection of the Guarantee Fund, the Virginia State Guarantee Fund, that will be supported by all life and health insurers. To me, if you want your constituents to have long-term care policies to be protected in the event of another insolvency, you'll support adopting this Model Act. And if you want to see more safe and sound fund in Virginia, one that's more fair and equitable distribution of the assessments, you'll support this act. And it only hits any life or health company if there is, in fact, another insolvency. And that's something that we have great concern about.
The same program, but just hear from the rest of y'all. I think Reggie covered. If you got anything new or articulate you want to add to it, briefly add to it.
Relatively new, probably not articulate, Mr. Chairman. Mr. Chairman, Miles Loria representing Care First Blue Cross Blue Shield. We are the not-for-profit Blue up in Northern Virginia, and Mr. Jones mentioned that there are those who are going to pay more. Care First Blue Cross Blue Shield is going to pay more. We understand that. We believe this is just a matter of good public policy. Broadening the base is going to protect consumers.
Thank you.
Thanks.
Did you see Senator Peterson's barber also?
He does it himself.
Okay. All right, thank you. Next.
Good afternoon. I'm Bill Gray for Metropolitan Life Insurance, and we also approve this bill.
Thank you.
Good afternoon, Mr. Chairman. Chris Legault for AIG, and they approve the bill as well.
Thank you.
Mr. Chairman, Chris Peterson, also representing Virginia Association of Health Plans. I was part of the NAIC working group that drafted this legislation, and I just wanted to let you know that almost all national HMOs support this. Many nonprofits, including the Blue Cross Blue Shield Association, supported it. A wide range of support all throughout. It made it sound like it was a rushed judgment. We had twice weekly calls for 6 months. 3 different hearings on this, 3 different proposals considered. So this was not a rush to judgment. This was a very well-considered thought The NEIC believes it has to happen because they're concerned that future long-term care claims will not be paid, because they believe there will be another long-term care insurance insolvency up north. So they believe in order to take care of senior citizens and others on long-term care claims, this has to happen. And they also believe that providers, under Virginia right now, HMO goes insolvent, doctors don't get paid. That's why the AMA supported this, because they think doctors should get paid. We have seen in other examples of HMO insolvencies, when doctors aren't paid, care isn't delivered, because doctors and hospitals can't be expected to give away free services. So I just want to make certain you understood this was well considered, supported by almost all groups at the national level.
Thank you, sir.
Mr. Chairman, members of the committee, Morgan Guthrie, Chair on behalf of Delta Dental, Virginia. We support House Bill 1486 as a standalone dental-only carrier. We could argue that we should not be subject to the Guarantee Association system and resulting in the multi-million-dollar assessment that we received a year ago due to an insolvency of a long-term carrier.
Hang on, hold it down.
However, we're not lobbying to be exempted. We understand that there is value in broadening the base as wide as possible so as to impact insurers to the smallest degree possible. We would hope you would support the bill.
Let's be briefer. Let's wrap it up.
Yes, sir, Mr. Chairman. Fred Helm on behalf of Aetna. The only point I would make, and we support the bill, the point that hasn't been made, I think, from our end is that, Kaiser's HMO competes with Aetna's HMO every single day. And there's just no sound public policy reason to exempt them. So thank you.
Hi, USAA is in favor of the bill.
Thank you. SCC, what we got from insurance today?
Over here.
Were you at this commission where everybody was voting? That was referenced?
My name's Don Baden with the Bureau of Insurance. That vote was taken by a telephone vote. I did not participate in that phone call.
Okay, Don, what's your opinion on the bill as a whole?
The Bureau has no position on this bill.
Well said. Way to stand in there, Don. Okay. What's the status of the fund? Can you tell me that?
No, I can't, but I know Peggy Parker is here, who is the executive director of the fund. She can give you more information on that.
Peggy? Here we go.
Mr. Chairman, members of the committee, Alan Goolsby, Counsel for Guarantee Association. The issue here is that only a very limited number of companies, primarily life, I guess, actually wrote long-term care. Mm-hmm. Most of them have gone out of writing the business, but the exposure of gross underwriting that occurred in the late, say 1990 to 2000, before we realized the impact of dementia and things like that, expected long-term life has left a real exposure in this area. And we have the ability to assess. Penn Treaty in Virginia, we assessed last year $190 million. We have a very good system. What you're trying to do in some way is decide, how do we spread this cost? If you simply said, pure fairness, only if you did or do write it, you pay, you'd immediately put them in the tank.
Thank you.
Immediately.
Okay, thank you. Thank you. You want to
Mr. Chairman, members of the committee, Peggy Parker. I'm Executive Director of the Association, and to answer your specific question, the status of the fund is very solid.
Okay. Give it until, okay, thanks, Peggy. Thank you. Okay, I think we've heard both sides. Delegate Kilgore, I think we're ready. Okay, committee operates by motion. It's been moved and seconded that House Bill 1486 be reported. Clerk, open the rolls. I want to thank Senator Stanley for allowing me to explain this bill on the floor, but I appreciate it. Okay.
13 ayes, 1 nay, 1 abstention.
Clerk, close the roll. Okay.
And finally, I got one more bill, Mr. Chairman.
One more bill.
And I don't think there is a.
You've had an awful lot of success today, Delegate Kilgore. All right, is there a motion on the amendment? Been moved and seconded that the substitute be agreed to. All those in favor say aye. Any opposed? No.
All right. Mr. Chairman, House Bill 1252 is a bill that's designed to expand the Dominion and APCO pilot program to apply to Kentucky utilities. It's limited there to 7 megawatts cap, and it extends it to nonprofit extends this to nonprofit individuals, PPA pilot into those type of customers, like from just private colleges to all schools and nonprofits. So what that would be, it would allow some folks who are not able to use it, such as schools and nonprofits now, other than private colleges, to use it. And I have somebody here to speak. Come on up and explain the bill here. But that's the gist of it. It's a PPA type project. Yes.
Okay.
Thank you, Delegate Kilgore. Thank you, Mr. Chairman, members of the committee. I'm Adam Wells with Appalachian Voices. I'm here today from Wise County to speak in support of this bill, which provides economic relief and spurs investment in a rapidly growing industry in the coalfield counties of Virginia. HB 1252 does this by taking an existing pilot program and expanding the eligibility to include schools, government buildings, and other nonprofit charitable organizations. Just one example to share is that Dickinson County's one consolidated school, Ridgeview High School, would save over $1.5 million over the guaranteed lifespan of the system, of a 700 kilowatt system that was installed. And Delegate Kilgore's bill enables Ridgeview High School to take advantage of power purchase agreement and the federal 30% tax credit before it sunsets to reap that taxpayer savings.
I'm a little confused because Appalachian Project got up and opposed directing the State Corporation Commission a little earlier on 5,000 megawatts, and now Appalachian Project's back. Appalachian Voices
Yes.
Is back now saying, no, but we want the SCC to do this project. I'm confused. You want something on one hand, and then you stand up and oppose it on the other hand. Can you explain that?
Yes, sir, Mr. Chairman. Civil disagreement is the cornerstone of democracy, and I'm not to be,
Yeah, that's
quip,
true.
but I'm a constituent of Delegate Kilgore's,
Yeah.
and this is a broad-based effort that we have that came out of an economic development forum in 2015, hosted at UVA Wise. Several members of the solar work group got together and met with Delegate Kilgore to talk about this legislation, because it would enable taxpayer savings on so many buildings in Southwest Virginia and be critical to accelerate the growth of a solar industry in our home.
Well, I got to tell you something. I got a problem with a group standing up to oppose something that asks for 5,000 megawatts of solar and then coming in and saying, no, you're forcing the SCC's hand and you're making them do these kind of things. And then you turn around, I'd say within an hour, but it's been a couple hours, and come back and say, but we want this for our side of it. I got a real problem with that. And, but as the case may be.
Mr.
Senator
Chairman,
Obenshain.
With respect to Delegate Kilgore, he's been very successful in persuading us today. I would suggest that maybe we give the chairman maybe 10 months to cogitate over that conundrum that he just expressed, and that we carry the bill over for the year.
I have a motion properly endorsed to carry the bill over. It's been thirded now. Clerk, open the rolls.
All right.
Yeah. Close the rolls.
13 ayes, 0 nays.
Okay. I would hope to clear the docket, but we have one more bill and probably another.
I'll work with you on
Okay,
this.
we have one more bill and a judicial interview to do next Monday. So I think a couple of more judicial interviews. So with that, the committee will rise.